Now,
Now the matter has been come by order. We are not informed, Lordship, that the matter is being.
wait. We'll see.
May I
Yes.
please? May I please? Lordship, with the consent of the other side of document item 43 and 44. And for the respondent, Lordship, and allow 3 weeks time to file our affidavit, Lordship. Wherefore the income tax department.
Learned Council, Standing Council for the Income Tax Department, press for and is granted 2 weeks time to file
3
affidavit.
weeks, Lordship.
3 weeks time to file affidavit in operation. Any interim order? Interim order, pass earlier, shall continue.
Apply. Please. We are filing IA for correcting typographical error in the order. Matter was listed supposed to be listed today, Lordship. But somehow it didn't come up. Lordship, may kindly take up the matter with 2 o'clock.
No, any urgency?
Lordship, the salary has to be released by 5th, Lordship.
5th of
April.
We'll take up tomorrow.
Yeah, please.
Give a mention, ma'am.
Lordship, 22nd, tomorrow, Lordship. There's some urgency with the department. Yeah, please. I'm paying for listing one, Lordship. Title.
What is the issue?
Eviction drive or
Okay. Already evicted.
Evicted, Lordship, but some people have been rehabilitated, Lordship. We have also updated, but not today. Deeply up. May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 25 from today's
25.
In this case, my lord, the respondents have filed their affidavit in opposition. We want
When?
vote, my lord, on 18/3/24.
Okay.
My lord, we want some time to file and reply to that
The
affidavit.
Learned Council for the petitioner press for and grant and is granted 3 weeks time to file reply affidavit. Rejoin the affidavit.
I'm deeply
Please
obliged.
record it. Yes.
General meeting should be held. That it take it up.
Okay, the change of the name.
Yes.
Okay. On the prayer of the Learned Council for the petitioner, may trust and adjourn and be listed after 6 weeks.
Wait, please, Your Lord. With the consent of the other side, I beg to mention item number 50 of the daily list.
50.
Instructions are being awaited in this matter. Some more time may be given.
What kind of instruction?
My lord, the petitioner is challenging a so-called notice, my lord.
You are for the finance and taxation.
Finance and taxation department.
Okay. Learned on the prayer of the Learned Council for finance and taxation department, may trust and adjourn and be listed after 3 weeks.
For the petitioner, there's an interim order.
Interim order pass earlier shall continue till the next date of listing.
Hello.
Yes.
I beg.
40?
45
Yes.
to adjourn for the day.
Why?
It's an ARPI is out of the day.
Why is the matter is listed?
But the matter pertains to
No, why listed in the order? Hey, yes. Why matter is listed in this? This is admission 45.
Yes.
Okay. Why you want time? Any interim order?
No.
Okay. On the prayer of the Learned Council for the petitioner, matter states adjourn and be listed. When? After 2 weeks.
I beg.
Huh? On the prayer of the Learned Council for the petitioner, matter stands adjourned and be listed. No. Either you do it today or it will go after view. After view vacation.
With the consent of the other, but I beg to mention item number 62, Your Lordship.
62.
Connecting consent, Mr. SP is out of petition, Your Lordship. May the matter be adjourned for the day. the phone, I have filed my affidavit.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 3 weeks.
May it please your lordship, I beg to mention for district petition for motion.
Hmm.
Lordship, may it come up.
What is the urgency?
Lordship, order has been passed. Order in original has been passed, and recovery issued may be the process may
GST.
yes.
When?
May it come up on Friday.
Monday.
Okay.
Monday is a holiday.
Yes.
Huh? Okay, Friday.
Apply.
Monday is a holiday. Huh? No. This next Monday is a holiday. So give it on Friday, please. Yes.
I would like to mention item number 9, certificate.
Hmm.
My senior is having some particular
Uh,
Date me
huh? On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed on after holy given. Impugn order was passed long back, terminating the contract. What will you decide? Yes. 1st of April. No, immediately. Motion. During this, 27th, 28th.
no lordship.
When you want?
But-
Give a date of 1st of April. 1st of April. Any change in the situation?
My lord, we file an affidavit to comply the order of time is granted. This last order. 10th of June, matter is fixed. Time is granted. Whether it will pursue this, economic participate or from finance department.
Now what to be done?
Sometime we get so whether this petition you will pursue or withdraw my lord in this regard 10 days time.
We'll adjourn this.
Yes.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed
For
after 4 weeks.
date.
Give a date after 26th. Or if you have any convenient date, 30th of April.
I'll have
Yes.
in this case, I have received the instruction.
Yes. What is your instruction?
The instruction regarding my lord that one succession case is pending before my lord.
Okay.
That's why my lord that is the very challenge before my lord. I may please apprise the board about the facts of the matter. My lord, amongst other things, I am challenging the impugned communication dated 3/2/2023 at page number 40.
What is the other writ petition? There are some.
First writ petition.
Where is that?
Yes, I will just highlight the order at page number 40. This will more or less give us a clear picture on the facts of the matter at page number 40. My lord has it? Yes, paragraph number 2. Okay. On the death of his father, Adilur Rahman, my lord, this has to be read as a brother. Typographical error. The petitioner was aggrieved that the next of kin certificate was obtained by the wife and the daughter of the deceased by suppressing the necessary facts, and the petitioner is also entitled to the said NOK certificate. Accordingly, the petitioner lodged a complaint before the DC Kamrup Metro on so-and-so, which was registered as so-and-so, for cancelling the NOK certificate issued to the wife and daughter of the deceased, Adilur Rahman. This writ petition is instituted on the grievance that although the hearing was conducted by ADC Kamrup, but so-and-so has not been brought to its logical conclusion and no final order has been passed. Considering the limited grievance raised, we
So
directly
there has been directed to pass an order.
stop.
Now,
Thereafter, my lord, since no action was forthcoming, I write to them at page number 40.
then
Even then, no action was forthcoming, which prompted me to file a contempt case. Now, the contempt case order is at page number 45. If my lord may kindly have. This is the order dated 19th of July 2020. Para number 2 again. Learned counsel appearing on behalf of the respondent number 1 and 2 has submitted that the order has been duly complied with. And in that regard, Mr. So-and-so learned counsel has placed on record a communication dated 3/2/23. So this is what I have now attained amongst all the other things. My grievance is on a limited aspect.
Okay.
My grievance today is on a limited aspect. 30 days time was given for disposal of my complaint. Thereafter, this communication comes in wherein the proceedings have been kept in abeyance pending the succession. In my respectful submission, my lord, that is a completely different matter, which is under the Indian Succession Act, and this will be regulated by different services.
Now, what is the meaning of a next to kin certificate?
Next of kin certificate is an acknowledgement in relation to the close
Next of
relative
kin, next of kin is a certification where an authority will certify that these and these people are next of kin of this person. Now already a dispute is being, there is already a certificate has been issued.
Yes.
You want a cancellation.
Yes.
Where is the power of cancellation and under what authority?
My lord, may kindly see one document which is of relevance at page 30.
Page 32.
30. This is the cross-examination of Afroza Rahman.
No, that is not the issue. Issue is where is the power of the deputy authority issuing next to kin certificate to cancel, number one. And first you issue a power of the authority to issue a next to kin certificate, then cancellation therefore and validity of such a certificate. And why should this court in exercise of judicial review enter into all disputed facts, cross-examination or what not? According to us, prima facie, the deputy commissioner has rightly done his exercise because a competent civil court is determining the dispute between the parties relating to the same issue. You also want a cancellation here, then there is a succession. We do not find any wrong in this case to be judicially reviewed.
My lord, this communication at page number 46. My lord, this will not tantamount to be an order. I am only saying that since there was an order of this honorable court saying that the matter this way, that way has to be decided on merit. The authority that has issued.
It is the decide that is your decision.
And this is more on the line of a communication. Plus, I am also agreed, since in that order, it was stated that a fair hearing be given to the party. That has never been
They
given.
thought that there is no scope of now
Only
giving
on that
fair
limited-
hearing.
I
We do
completely
not
doubt
think this is because it has been closed as contempt. Contempt is closed in view of this determination. Court held that there is no contempt. Is not it? So if there is no contempt, now we will see this whether this order can be judicially reviewed
My lord,
in the given facts, admitted facts.
I was only on a limited aspect. This way, that way,
Better way to
that the
withdraw this
application-
petition and await for the decision, or otherwise any comment passed in this petition may affect your right in the succession. That is the difficulty. You are inviting an unnecessary litigation.
I was only on a limited aspect for your lordship's consideration. That is, succession would be on a different premise. Even in the cross-examination of Afroza Rahman, she has acknowledged me as a legal heir, which I wanted to show my lords. This is-
Fine. So you want
maybe
to
this is
do
a disputed fact.
should we record that since so and so has taken? So can the deputy commissioner pass an order relying on a cross-examination of so and so to cancel? Is it as adjudicating authority who is next to kin?
My lord, in that
Is it
case-
an adjudicating authority?
I understand what is
So
what-
better you withdraw this petition, or we are going to pass an order right now.
But my lord, if there is non-compliance, the contempt is not an issue anymore. I am only saying that my complaint has been decided on merit. The authority that has issued the NOK has also power to withdraw it, has also power to cancel it. Now, since that has not been done, hence I have come before my lord that this particular communication, wherein the same has been kept in abeyance, might not be correct legally, because in the same order of the High Court, my lord, I may be permitted to read that order once again. There was a particular observation that a hearing be given to the party. No such hearing was since given.
And
it's a
that
violation of
you
my
have
principles
alleged in
of
the,
natural-
that you have alleged in the contempt, and on this order which is under challenge, court says that no contempt. So non-giving you a hearing is to be considered in a contempt, not here.
My lord, at page number 18, in fact, I have highlighted the prayers before this court. At page number, my lord, may kindly, at 14, I'm sorry. At page number 14. A. A writ in the nature of mandamus to dispose of the complaint dated so and so by providing an opportunity of hearing to the petition. So I was
Yes.
only on that limited aspect, page
Yes.
14.
Page
really-
14 prayer.
Prayer A. A writ
Prayer
in the
A.
nature
So
of
you are
mandamus.
insisting on prayer A.
Please, my lord. A writ in the nature of mandamus may be issued directing respondents to dispose of the complaint dated so and so, registered and so, by providing an opportunity of hearing to the petitioner. Since this is calling from the order of the court, I was only hoping that may I be allowed to at least put my grievances, because this is only in line with the order of the court, nothing beyond that. In my respectful submission, my lord, this may be in violation of my principles of natural justice.
Where is your cross-examination?
Yes, cross-examination at page number 30.
This is cross-examination relating to
The
what?
succession key, which is the basis for this particular application to be kept in abeyance. My lord,
What do you mean by a next to kin certificate, and where is the provision of issuance of such kin?
it's an acknowledgement regarding the
Why do not from your mouth? We want the power of the deputy commissioner to issue next of kin certificate, and how it has been defined as, what is the definition of next to kin certificate?
my lord, I will put those particular things on record, but an authority that has issued something.
No,
can
an
also be-
authority is to act under authority.
Yes.
They cannot issue that I like it to issue an authority. Where is the power to issue a next to kin certificate?
If it has
And
been-
where is the validity and what is the sanctity of an next to kin certificate?
if it has been-
When more particularly when the dispute is pending for on a competent authority regarding success.
in that case, if it has to be kept in abeyance till the succession, then let there be a stay on the cancel on the next of kin itself. I am saying if it applies to me, it should also apply to them. If the learned ADC has exercised their jurisdiction to decide on
This is not your case. You are not saying that you don't have any
No, this is
authority.
fallen from my lord. I'm
No,
just
that's
trying to
why
assist
it's so,
my
it
lord.
is not your case that they have no authority to, your next of kin certificate is not under challenge before this court.
It is, my lord.
The-
I've challenged it.
what is your grievance is that as
At
you have
page 14.
projected.
No, at prayer number B, my lord may.
Now you said you have confined to prayer 1. Now you want to
No,
go
no.
to prayer B.
No, I'm so sorry because this has fallen from my lord.
Hard,
So it is my-
Mr. Swenso, learned counsel for the petitioner, issue notice. Returnable after 6 weeks. Where is the private respondents?
Private respond number 3 and 4.
Mr. Hendrik accepts notice on behalf of
For 1 and 2.
1 and 2. 1 and 2. Are steps upon other respondents to register post with AD.
So,
AD, as admittedly a succession case is pending between the petitioner and respondent, private respondents, this court is not inclined to pass any interim order staying the succession certificate under challenge.
perfect.
Where is the contract?
My lord. It is general terms, my lord. And arbitration clause at page 30, my lord.
Yes,
Page 30.
30.
Yes.
No, where is your contract entered into between you and them?
Oh, my lord,
Mr. Sahu, learned counsel for the petitioner submits that he may be permitted to bring on record the contract entered into between the parties relating to the dispute in question. Prayer is allowed. Please this matter after.
my lord, page
No, you have not annexed.
18, my lord. It is-
Where is your contract? You have no, we understand that the arbitration clause is guided by the general
Yes.
GCC
Yes.
2019-18.
Yes.
But if there is a SCC between you and him,
Yes.
Where is that
And it
SCC?
is
And in
only
S
work
and
order,
SCC also there is a clause of arbitration.
but
Or there is a clause that arbitration will be applicable in terms of the GCC. Where is that? Yes,
India, dispute at page 64. Page
Page?
64. Page 64. Para 3, as per condition of 65 IAFW 2249. That is annexure 2 meter. General conditions of contract forming part of.
Oh, we understand. Where is the contract between you and him? At least
that
first page.
contract paper is not there, but work order is only there, meter. And by
Where
this,
is the work order?
that I have not.
Then
That work order. I have.
we do not know what contract, what will you dictate? Mr. UK Goswami, upward likheba. Heard Mr. Sahu, so and so, and Mr. UK Goswami. Council, Mr. Sahu, submits that he may be allowed 2 weeks time to bring on record the contract. List accordingly. Yes. On the prayer of the learned counsel for the petitioner, methods then adjourned and be listed after holy.
My lord, in this matter, my lord, the petitioner have a plot of land, my lord. Out of that plot of land, the government of Assam has acquired a land by direct purchase. Misery 6 acres. My lord, for that portion, my lord, I have got the compensation, and I have some house, some type house. For that
Or-
also, I have received
The learned counsel for the petitioner. The grievance of the petitioner is that the patta land belonging to the petitioner has been acquired under Assam Mala scheme through the process of direct purchase, and compensation has also been paid. However, compensation against Zirat,
No, my lord. My grievance is
yes,
I have two houses.
not RCC building.
For house.
That let us complete this. According to you, that RCC building is not been given.
Not
It's
given.
not. It's not.
Not for RCC building even.
Uh,
Some type house.
But who will decide this?
My lord,
Under Assam Mala scheme. Yes, who will decide this? Mr. Handik. Direct purchase, who will dispute, what is the dispute redressal given under Assam Mala? No, we understand that, but we have experiencing cases where you say that this is Assam Mala and you determine on your own the amount and ask them to pass an award. We have seen that. We have seen that. That was you are asking. Here is a case. If it is a settlement, then where is the settlement award?
my lord, award is at page, my lord.
That's why we want to issue notice. We want to get clarified. And we may question you on next date. If this comes to this court, under what authority of law you have formulated this scheme Assam Mala, and whether that can be done in view of the existence of 2013 fair compensation. We'll take judicial notice of this. Come on. Compensation has been paid. Compensation will also be paid. However, while determining such compensation, the compensation against Assam type house and Jirat has been calculated, ignoring the the RCC building standing upon the center. Issue notice returnable on 24th of April.
I'm
Yeah.
correct. What-
Accepts notice. Also, just give the who accepts for whom give them notices. All are represented. No, any notice to be gone through register book?
No, but
Accepted. Copy within 5 days. Okay, registry to list, reflect name of GA Assam in the cost.
my lord, may I prepare status code regarding that portion of land, my lord? Request.
Construction of road.
No, my lord. Regarding utility area.
None appears for the petitioner on call, list of the weeks. Same, 10 and 11.
Look, let's see the annexer T, my lord, page 12.
Annexer,
T, page 12.
yes.
The electric pole has been passed through over the fertile land of the petitioner
Hmm.
without any authority and without issuing notice, without consulting with the petitioner also. Then an inquiry has been conducted, page 13. Whether my contention was correct or not, okay, and take appropriate steps for removal of.
We are issuing a notice.
I'll come back with it.
Hart, Mr. Post, learned counsel for the petitioner. Also Hart, the appointed standing counsel for the APDCL.
Correspondence number 2, 6, and 7.
APDCL. Mr. Kotogi Wafo. Respondent number 345. Kotogi for 345. So who is 6 and 7?
2, 6, and 7.
You are 2, 6 and 7. The grievance of the petitioner is that what do we call it? Grid line. Huh? The grievance of the petitioner is that electric power line has been, what is called, this is something, some word with their grid line or what, where is the communication?
Page 13, page 13.
Page 13.
Yes.
That electric poles has been constructed over the private land without prior permission of the petition. First of issue notice, returnable 4x, accepts notice, extra copies, 5 days. They may have done it under Telegraph Act.
Yes. There is even a billet.
Separate provision, Telegraph Act,
There are also provisions
Ah.
for taking land.
not necessary always.
There are judgments.
Not even judgment, that power has been given under Telegraph.
So if alternative provision is there, then
And that is to be done, decided by some competent authority, deputy commissioner is there. This is only right of, sometimes they can, damages are to be given when constructing the pole, if that cultivations and etc. are damaged. So that,
it's
Telegraph Act.
cultivable land.
These are, whether we can decide this, we cannot say that remove it.
Uh,
If no, there are some alternative redress mechanism here. Go through the Telegraph Act and the rules from there.
Let's take it up.
Yes.
I am challenging the notification matter 0 of 23 matter. I challenge notification 9 of 23, my lord, whereby my lord time limit.
Your time limit, where is that notification?
My lord, page 43, my lord.
Page 43.
Entire have been pending in court.
Because this basically this is whether you can have a issue notice beyond the prescribed period and whether pandemic that judgment will cover your case.
I've given the similar order as passed by similar
Huh.
coordinates.
But here, we make the decide because many case has been admitted.
And nothing has been decided in any other high
Nothing
court.
has been decided.
It's not in the past, my lord, not to me, it's
Ha.
I'm
Notice
saying for similar order.
We'll do that. We'll do that. Give a copy.
A copy I've given.
that 168, the government has power to extend.
Ah.
In the special setup.
Okay.
And that has been by the GST Council.
Mm.
Consider all these aspects and asked necessary.
Do you pass such a long order?
Not
Or
because
notice?
Huh?
Hard.
here it is provided that they will file their reply.
Mm.
Department will proceed the matter, but they will not file any final. That is provided.
In this case, sir, I have filed my reply.
Okay.
They may not process final.
Not pass any final order till
Okay. Hard. The present petition is filed. Assailing. Please tell us quickly.
Notification at page 43,
Notification
Nine of
number 9 of 2022. Isn't that it?
23,
Huh?
23,
2022.
23.
23.
page
On
43,
31/3/2023.
my lord.
Huh?
My lord.
Notice number 09/2022/23.
As well as next page, notification number 56 or 23.
Central Tracts dated 31/3/2023 issued by the respondent number 2 extending the period for issuance of notice in exercise of power under section 73 within bracket 10 of the GST Act 2017. The further challenge is the notification number 56/23 dated 28/12/2023 issued by the respondent number 2 extending the period for issuance of order under section 73 within bracket 10 of the CGST Act 2017. The further challenge is the so-cause notice issued, so-cause notice dated 8/12/2023. Full stop. Similar matters, in similar matters, notice has already been issued by this court, and and as an interim measure, it has been provided that
Last page.
provided that till the returnable date, the proceeding initiated pursuant to the so-cause notice may proceed. However, no final order in respect of the impugned so-cause notice shall be passed. It is submitted by the learned counsel for the parties that in the case in hand, the petitioner has already filed his objection to the impugned so-cause notice. Be that as it may, considering the matter in entirety and in view of the detailed order passed by this court, passed by a coordinate bench dated 1/3/2024 in WPC 1170/2024. It is also provided that till the returnable date, the GST authority, though is permitted to proceed with the proceeding pursuant to the impugned so-cause notice. However, no final order should be passed till the returnable date. Upward notice except by
2 to 6.
2 to 6
Therefore,
Kyle?
it's about the
Union of
DPF.
Okay. Wait for something. You are on behalf of?
Right.
Huh?
Right.
Yes.
Matter that he has applied for the certificate as per verbal instruction that I have received today. His application is rejected on 18th of August last year due to some wrong submission of documents.
You have that copy on the next day.
Might.
You can have it
I
because
have
it's
placed I will place the instruction.
the present writ petition is filed alleging that his application dated 4/7/2023 filed in Seva portal.
Yes.
Filed in Seva portal seeking partition or what? Huh?
For lease,
Huh?
For lease.
For seeking permission to execute a lease deed has been kept pending till date. Full stop. The learned GA Assam on verbal instruction has submitted that such application of the petitioner was rejected way back on
18/8 of the
18/8/2023. In view of such instruction, the matter stands adjourned and be listed on. When can you have it? Then at least you will have a right for the first appeal, second appeal. There are provisions.
next week.
Okay, next week give a date. 28. 28 or 20. Huh? Madam, there is a delay, period of delay. We are for to help you. We are doing this. Otherwise we can close it. We can get the copy,
So that
give it to you so that you can prefer an appeal. For you, we are doing this. We do not require any law point to be argued here. On so on which that the learned state council shall produce a copy of such rejection.
it is available in the portal.
Ah,
I can
Just-
print out.
okay.
Lordship, the lyric that took care of within lack of kindly matter we picked up at
Yes, Burua.
Well, for
What is your right that has been violated by the state?
para 7 April or to come.
This
Such
is
a
a
guideline.
purely a dispute between the members of their society. Your remedy lies somewhere else.
Well, I'm on a point, my para 7. So
There are 7.
yes, the condition and guidelines.
There are 7.
Yes, and as per that paragraph 7, my lord, condition are half para, page 9.
You are filing a case against yourself.
That is, my lord, the fundamental rights of all the person who have genuine rights.
But
For
this
them-
is a society. Your right has been violated by whom? A writ can be issued when a right is violated.
Well, I'm on a point, my lord, I'm coming to sanction order if your lord could see.
Heard Mr. B.
Thank
Purua
you.
learned, but we are not passing any interim order.
Well, only thing is that they have to procure the land on permanent basis. Now, what they are doing, my respondent to
Let us have response from the AIDC.
only one guideline I want to.
No, I have seen that. No, don't expect any interim order today. Rightly, wrongly, an institution is being run. They are getting some sanction. You are part and parcel of that society.
That is not established still. This is the infrastructure.
Okay, but you are a part of that society.
Yes,
You are part of society. Your grievance is that the other members of the society are not exercising or performing their duties in terms of the sanction.
Lord, I may be wrong, my lord. That is not my grievance, my lord.
What is your grievance?
My grievance is page 31, my lord.
Yes.
Page 31, Annexure 7.
Hmm.
The condition for release and utilization.
Okay.
as per the conditional release of funds issued by Commissioner of Industries,
Hmm.
whether this is directory or mandatory. So as per this condition, my lord, your lordship
So
will
what
see-
do you want today? That there should not be any sanction released.
No, they have already released a part.
Ah.
But that release is for establishment of permanent infrastructure.
Ah.
That includes the cost of the land purchase.
mm.
But what the term of the authority, respondent,
So they have not done it.
they have not done and the fund.
It's diverted for something else.
Yes.
Is not it?
And our right is, my lord, that as we are rice mill holders,
Ah.
we will facilitate from that service and we'll pay 20% contribution. But that has to be looked by the, my lord,
This industry.
commissioner
Yes.
and industry. Their
So you are
side-
giving a huge money to an institution or a society. Society consists of different components of rice mill owners. Now, if the society is being mismanaged, is it not your responsibility
that is what
to look into?
But you will get the instruction.
these guidelines are totally violated. Not only that, no permission from state or center regarding pollution.
Heard
Police.
Mr. Borua, learned counsel for the petitioner. The case of the petitioner is that for sanction of a beneficial scheme by the state of Assam, a society was formed by the consisting of different small rice mill owners for establishment of
Common facility center
common facilities center
for premium rice processing
for premium rice processing
facility at Surat.
at Jorhat. It is the grievance of the petitioner that the scheme envisages construction of permanent
Permanent infrastructure.
permanent infrastructure. However, the society has mismanaged such fund and the sanctioning authority, that is the Industries and Commerce Department, is not looking into such matter, resulting in deprivation of right of the small rice mill owners like the petition. Issue notice returnable on give a date after 4 weeks. After Bihu, give a date after third 3 weeks, returnable on immediately after Bihu. 19th of April 2020.
My lord, that I put
Okay, give a date.
on 22nd.
22nd of April 2024. Full stop. Also notice on interim prayer. The learned counsel for the Industries and Commerce shall apprise this court whether the allegation made in the writ petitions are correct and the project is being constructed in a rented premises
Of a member.
of a member instead of going for permanent construction, though money has already been sanctioned for that purpose.
That is
This is your case.
Yes.
Right.
obliged.
Who accepts notice for whom give a slip and give a
Well,
slip to them and
Notice
go
may be issued-
within 5 days.
notice may be issued to respondent for
Respondent number 4 to
By
registered with
obliged.
permitted to serve dusty also to be routed to the register. Yes, yes.
Hello, by this application, we have changed the order in original dated 12/1/2024,
Hmm.
passed by the respondent of fee. Is the matter related to service tax?
Hmm.
My lord,
Your case is no notice.
no note. I have
What
not
you
received
say?
any.
Not me, issue notice, so we'll respond to.
You respond it. The grievance of the petitioner is that the present writ petition is filed challenging order in original number 147/AC DIV Sailova, dated 12/1/2024, passed by the respondent number 3 for the financial year 2016-17. The basic grievance of the petitioner is that such determination has been made without issuing any notice or giving any opportunity of hearing to the petitioner. This is your case.
And this tax is not, it is only exempted.
That is to be decided by whom? Suppose notice was there, then who would have decided this? Isn't it? If notice is not there, we will set aside. If you are satisfied, send it back. You argue that point.
Fine.
Okay. Considering the issue notice returnable venture, considering the specific stand that at no point of time notice was received by the petitioner, it is provided that till the returnable date, no coercive action be taken pursuant to the impugned order dated 12/1/2020.
But the question of maintainability may be kept up.
Okay, Mr. Question of maintainability is kept up.
Much so.
Or for having alternative remedy.
Yes.
For having alternative remedies.
Much so.
Yes.
Here, what has happened, your lordship may kindly come to page.
Yes, who is representing? Let this matter be listed. Where is that other matter fixed?
Your lord. 27.
Let this matter be listed day after tomorrow along with
5/9.
5/9.
2/2020.
2/2020. It has been sealed. Let us wait for two more days. Let us, what is their instruction? There is specific direction. You have overacted. And that's makes malafide. 22nd. Madam, please have the instruction. See the earlier order, the date of action on the impugn in this present petition. They could not even wait till 22nd. So prompt.
Our case is other case 27.
27. So we are fixing, we are bringing it day after tomorrow along with this motion. Yes.
Applied for building permission under the petition of 2023. However, this Nagaon Municipal Court, they are sitting over the matter.
Who is respondent number 3? Who is representing respondent number 3?
I think it will go.
Notice.
We have submitted representation
Heard Mr. B.K. Das, learned counsel for the petitioner. The grievance of the petitioner is that the petitioner filed an application for grant of no objection certificate for construction of an RCC building over his Miadipetta land, and such application was filed on 22/5/2023. However, the Nagaon Municipal Corporation has not taken any decision on such application till date. Issue notice returnable. Issue notice returnable. Give a date on immediately after. Can you take Dusty upon Nagaon?
I will.
Then we can after Bihu. 38th?
No.
38th of April 2024. Bormon accepts notice on behalf of respondent number 1, 4, and 5. 1, 2, 4, and 5. Petitioner to take steps upon respondent number 3 and 6 through the usual process as well as through the Dusty. Through registered post AD. The petitioner is also permitted to take steps upon respondent number 3 and 6 by Dusty to be routed through an affidavit. Problem.
But that's a concept. Pendency of the case may not be a bar
Pendency of this case
considering
shall
the
not be
issuance of NOC.
may not be barred to issue an NOC in terms of the application filed by the as per law. If permissible under.
May I please?
Yes.
Lords, I'm representing all the petitioners herein.
Hmm.
State government, the respondent authorities have evicted us from our own patta land, my lord, without serving us notice or without serving us
From
any
Pattalan evicted.
evicted. Without
Now, what
serving
is
us
the
notice.
prayer here?
A prayer is that, well, one aspect, my lord, is that they have evicted us. They wanted to build a market shed in our land under the scheme called Pradhan Mantri Jan Vikas Karyakram. Now the Millards
Who
may
is
kindly-
proposing to construct that?
Huh?
Who is proposing to construct the
Well,
state?
it's a central government scheme via the state government.
No, no.
No,
Some
Assam
there will
Government Marketing Corporation, my lord, ATM.
Assam government.
Marketing Corporation Limited.
Who is representing marketing corporation?
I think might be there.
Respondent number?
Okay.
Who evicted you?
My lord,
They will know.
eviction was done by the Deputy Commissioner, my lord, respondent number 5 herein.
Okay.
Now,
Now tell us.
well, let's just one aspect of this case that we were evicted, my lord, under the Pradhan Mantri Jan Vikas Karyakram. Now, according to the guidelines of this scheme, my lord.
No, we understand. You are already evicted.
Yes.
Now we want to know from the respondent. Now only option, if you hold that the eviction was illegal, only restoration of your possession,
Yes.
isn't it?
No, my prayer is that, madam, just kindly look into page number 40. The scheme does not call for land acquisition. The scheme itself does not call for land acquisition. They build these constructions in a land already available with the state government. So in our adjacent land, in the southern adjacent part of my land A, and now southern adjacent part land B, that is the government land. So they have to build the market shed in that land also. So they have grabbed our land in that. They constructed.
So therefore, your assertion, let us have a view of the deputy commissioner. What is the character of this land?
Well, it's a how to.
No, that is your case. We understand. Your case is that this is my patta land. I have been evicted for construction of some public project which is to be constructed in the available government land, and they have no right to evict us from the patta land. This is your case. Deputy Commissioner might say that no, this is a state. Since you have all, if it would have been a case that you have not been evicted till now, we would have granted you an interim order. There is no scope of passing interim order. Only thing is that what is the character of the land? We want to know that from the Deputy Commissioner.
We had been in possession since 1966.
That we understand. That is your case.
Yes.
Do you propose that without hearing we should believe your case and pass on?
That
So
definitely.
therefore, we are issuing a notice asking them, or we may not issue a notice at this stage. We will asking them what is the status. of that. Okay. Then we'll consider your any interim prayer regarding maintenance of status quo in respect of the land on the next date fix.
Okay.
Fine. Third, you are Mr.
That's Ahmed.
S. Ahmed, Learned Counsel for the petition. The grievance of the petitioner is that the petitioner has been evicted from their patta land without
Serving notice.
patta land without adherence of due process of law and without acquiring the land. Such, according to the petitioner, such land has been they have been evicted for construction of market shed by the local panchayat or Anchalik Panchayat.
Local Panchayat, Puspara Gaon Panchayat.
By the Gaon Panchayat. Full stop. It is the further case of the petitioner that there are some government land adjacent to the land of the petitioner, and such public project can very well be constructed over the said land in as much as the government can use the land of the petitioner for public purposes only after adherence of due process of law prescribed for acquisition of such land. Full stop. As a specific averment has been made that the petition land in questions are patta land and they have been evicted without due process of law. MS Burman, learned counsel for the counsel representing the deputy commissioner, shall obtain instruction as to whether the petitioner has been evicted from their patta land without due process of law. Full stop. The interim prayer for maintenance of status quo in respect of the said land shall be considered on receipt of such instruction.
Public.
List this matter on when, madam?
2 weeks.
Why 2 weeks? Decision C. If allegation is correct, that's why we're giving you a chance.
Free now. Election.
Election. So let us have a status quo. If for the election, everything is administration is to be stopped, let us have a status
I
quo.
will convey.
Okay, issue notice. Then we'll stay. See, it's a public project. We do not know whether it
After
land.
1 week.
Huh?
1 week.
Give a date. Before Bihu vacation. Before Bihu vacation. 2nd of April.
My lord.
2nd or 3rd of April, something like 3rd of April.
My lord.
Notice, not notice. Just it will be in the motion call.
Public.
No.
Can the matter be taken up for some time? Records are on the way, Lordship, because of the weather.
What is the issue here? Oh, that case. Okay.
Public.
But you will have to go through it.
I'll quickly go through.
Or tomorrow. Today, okay, we'll have to come today.
55, right?
Motion আছে নেকি আৰু? Supply. Mat.
In this case, we are filing an additional affidavit. It is in the process. It will come. It will take maybe 10-15 minutes for coming. Otherwise, I can produce a copy of that.
But
Yes, I have written.
see what are you proposing today in this matter? Affidavit is filed
My lord.
by state. They want to file an additional affidavit. We shall proceed.
Yes, my lord.
So are we going for a
Because
disposal or
yes,
an
because
interim
the-
order?
My lords, your lordship's convenience, frankly, my lords, the interim order is for us very important because
That we understand, but
Please.
that will if we'll have to decide, more or less we'll have to go details.
Lordship will have to go through the whole.
Okay, so if they have filed an additional affidavit, let us have it after this motions are over.
And today, Lordship is taking for final disposal. Main.
Let us see. Otherwise, Mr.
Yes,
I will have to.
Yes. We
Here
are not
tell-
shying away. We want to do it.
because we'll have to go either way to pass an interim order or to dispose it. of.
Because ultimately, Lordship, interim order will give the
Give
effect
the
of
final
effect.
Fine.
Yes. And that
Sir,
is the understanding.
we are
that's
having,
why we filed
they have
it.
filed an additional affidavit, just we are waiting to come. And after the other matters, we'll take up your matter. After some time.
grateful. We'll have to just look at the additional affidavit. We have no idea what they're placing.
So what?
Just I'll produce. Just I'll
Okay.
produce.
Okay.
So, deeply-
After some time.
In the additional affidavit, what we have done, after the impugned order passed on 12th of January, on 28th of January, that was about 2 months ago, the cancellation of the certificate order was also issued, which was not put to challenge.
But not without any intimation.
Anyway, we'll see.
Yeah.
My lord.
Great.
There is a
There
subsequent
must be
development.
intimation, my lord. Some order is in pass against me. There must be a communication, my lord.
Okay, just let us have this after some time.
My lord.
Obliged, my lords. Check.
Yes.
Well, it's a matter, it's a very sensitive issue.
issue is,
Issue is sensitive, but we cannot make determination on the basis of sensitiveness of issue.
no, I'm not on that.
So,
The facts of the whole thing are sensitive. I could say the fact. But thing is, when there is a report, inquiry conducted by government.
thing is this. According to you, there is negligence, sheer negligence on the part of the doctor.
Right.
Okay? So you file a complaint. Accordingly, they did their, according to them, they have proceeded. The doctor was put under suspension, then departmental proceeding. Then what they say is that suspension was revoked. He was reinstated
with some penalty.
with some penalty because according to them, there are some,
He was involved in private practice during that
because
period.
he was doing private practice. So according to them, the point of negligence in his duty is not there. Now, so far relating to the negligence of a doctor, you have remedy to of consumer forum where or any forum which is available, where it can be decided whether there was negligence or not. Now, we have serious doubt regarding your locus to silence the departmental proceeding. We are on legal issues. We have full sympathy for you.
That's a different thing.
That is absolutely different, but we cannot run courts and decide issues in exercise of power of judicial review on the basis of sentiments and emotions.
No, that is correct.
If that is correct, what is your locus to challenge his decision of the authorities so far relating to departmental proceedings?
My lord, we were part and parcel of the whole incident. No, the guardians of that this baby was not called for the inquiry. And kindly see the first inquiry report, that is at page 42. You will see that the clear findings of the doctor negligence were there. Thereafter, they went for another inquiry. And that inquiry report is not provided to us and we have not been able to obtain. But the speaking order is
Was it an inquiry? It's an inquiry under Assam Services Discipline and Appeal Rule, or is an
I don't know. But he was put on suspension. That document I have.
so suspension is of course under in exercise of power
In
under
discipline and appeal rules,
discipline
of course.
appeal rule.
Of course, my lord. But the inquiry report we do not possess. But the speaking order that your lordship can see at my lord page 81 and extra 11. The speaking order whereby there is no whisper of the thing that there was a negligence. My lord, how the baby died, kindly appreciate this aspect. This doctor, Dr. Rakesh Kumar Jain.
That we cannot.
Highly appreciate, my lord.
We cannot appreciate. We will cannot appreciate because that appreciation is a job of some other forum created by statute where it can appreciate evidence, can conclude that this is a negligence. That we cannot appreciate. That is the difficulty.
That can be determined by existing evidence.
That appreciation should based on an evidence.
Evidences are on record, my lord. That is my case.
So suppose evidence, you have all evidence. Can we determine a civil suit here?
No.
Then how can we determine whether there was negligence or not?
No, my lord, when there is a blatant violation.
Because
of the rules,
your whole case is that there was negligence, therefore he ought to have been punished.
no, kindly appreciate.
There will be standard of determining negligence for payment of compensation.
I am not asking for
No,
payment of
listen,
compensation here.
listen. For payment of compensation so far relating to a negligence of a doctor, the parameter for the determination will be different. And so far relating to negligence, allegation of negligence in a departmental proceeding, that will be different.
My lord would appreciate. Kindly allow me to speak for one.
Yes.
I am in this case, kindly see the prayer. I am not asking for any financial or any pecuniary or damage compensation from this honorable court. I know this common law remedy. What I have prayed for? That our government authority, on the face of it, when there is a serious negligence of practice, serious negligence of violations of the medical rules, prescribed a dangerous drug to a 4-year-old girl over telephone, and the girl succumbed to that, and is not taken care of by government administrative agency, then there is a serious negligence on that part, or not only part on the doctor, part of the administration also calls for an intervention by this honorable court under Article 226. This is my case. He advised to inject a medicine called lorazepam, which is barred by the Medical Council of India to be administered over telephone. And that was given to a 4-year-old girl. She succumbed to that. Nobody attended that baby. And that part has been ignored by the departmental inquiry, which is where I am aggrieved and I am before your Lord. This is my fundamental right. Restore my baby.
What?
This is my fundamental rights where it violated. They should restore my baby if they can. If they are not taken care of.
That is the thought.
It isn't the,
See,
my lord, I'm not on tort. Tort I will see at consumer court or civil court
yes,
for damage compensation.
yes.
I am here.
What is your grievance? Tell us.
My grievance is that, my lord, when a responsible doctor, a senior medical officer, administered a dangerous Schedule 10 drugs, my lord, Narcotics and Psychotropic Substance Act. Sorry, I don't have a right this moment, but I have annexed the medical regulations, which says that Schedule 10 drugs cannot be administered over phone, cannot be in any circumstance. Not only that, that doctor did not report back to the child when he was informed over phone that she is deteriorating. He never turned out. This is where his negligence is, and this is where has been recognized by the first inquiry report, has been neglected and negated by the second inquiry report. He has been exonerated from the charge. Only he has been punished by lowering his increment in salary because of his private sector. This is not acceptable. This is not acceptable. This is where my fundamental rights have been violated.
Sum and substance, according to you, the doctor for negligence should have been punished under service.
Yes.
Okay.
But he has been punished for private practice only, not for the negligence.
So the punishment imposed upon him is not correct. This is the summary of your case.
Yes.
Is
To
that
some
it?
extent. Yes.
Not to some extent. This is your case.
But that has
Because-
been how the second inquiry
Yeah,
report
that will see. What you are saying is that he was negligent. He issued the prescribed lorazepam over telephone that was administered are all facts, matter of facts. That has been taken note of by the entire.
that aspect, the second inquiry committee, that they did not gone into that aspect. We have asked for a copy of the inquiry report. They did not provide. They've just provided us the speaking on. Depending upon the inquiry report, which was the punishment was, the finding is that it's proved that he has gone for private practice. So violation of notification to also lower in scale for time being. And he has been paid all the back wages after he. We are not on that. But how did a government authority, a government agency can ignore that too? That aspect has been proved by the precedent inquiry, previous inquiry. Immediately after the incident, there was an inquiry by my lord will see that inquiry is done by Additional Director of Health Services, Lower Assam Region.
Where is the inquiry report?
Second inquiry.
Yes.
We do not have. I have expressed my.
But if he is relying on the first inquiry report, that is the relevant portion at page 44, my lord. The opinion, my lord, says, my lord. The inquiry report starts at page 39 and relevant portion, my lord, opinion is at page 44. Opinion portion right below, my lord.
It's page 47.
Page 44.
44. Oh, yes, sir.
In the emergency unit.
Yes, sir.
My lord, opinion is in the below, my lord, Dr. Rakesh Kumar Jain, Senior and Health Officer, Nalbari Civil Hospital, was indulging in private practice both in his chamber.
Opinion, negligence. Opinion. Okay, page 47.
47.
In my petition, it is 44, my lord.
What page?
Okay, you just leave the 47, okay?
Yes, my lord, that opinion portion.
No, my lord, not lordship will read the whole, not the opinion portion only. It is his personal opinion. The findings are different. Findings starts at page 43.
Yes?
Page 43. The report, inquiry report starts from page 43. Kindly read, my lord, paragraph 2 of page 46. Negligence by doctors and staff of Nalbari Civil Hospital. This is the clear finding. He was not attended.
Your grievance is against whom? Which doctor?
My lord, my lord, he was admitted in that hospital, not Nalbari Civil Hospital, under the supervision and instruction of Dr. Rakesh Singh.
Hmm.
But not only he did not attend the class, attend the patient. The other doctors available at that hospital, they also did not.
What is your prayer in this writ petition? Where is that inquiry reported at 7:10 that we have read just now?
No, that is not. That is dated 13/10/2020.
There
That
are
list,
two inquiries. This is the first
first
inquiry.
inquiry, there is nothing. No specific thing is there. We
Yes.
cannot issue a notice.
Second
In
inquiry, I do not know. The report is not with.
then under what ground you are challenging that?
No, that the speaking order says, speaking order does not talk about any negligence that has been proved by the first report.
Where is that negligence in the first report?
Kindly see page 46, paragraph number 2.
Where is the specific allegation against anybody? The doctor was busy in the emergency. He initially could not come. the patient was, as per protocol, could not be given some medicine until the report is given of the COVID, whether she is COVID positive or not.
And at that point of time, only one doctor was there in the
Yeah.
emergency ward.
Emergency ward, he was in emergency. These are the report. We do not know correctness.
The same report says that 40 numbers of doctors were available.
Available. But there is no findings that there was negligence. Doctors so and so doctors were on duty. They were not there. This is not an inquiry report.
Because the doctor who was there in the emergency ward, he called another doctor from residence to see the patient.
Yes, someone. They are dismissing it.
Well, at least if lordship issues an appeal, my lord.
This is not a court to decide all these things. Prima facie on the basis of the report.
But the
Yes, you can establish, you can call the
this
record.
aspect has been proved, my lord. I can show you.
Nothing is proved.
No, my lord.
Mr. Samo, I'll tell you. Listen to me. Whole allegation, 40 doctors were there. The records can be called by a consumer court in exercise of his power. He can summon it, record call it. It can be proved.
Lordship knows the functioning of the consumer court better than me.
But that cannot be a ground to
No, my lord will appreciate. Just one point I am just arguing, my lord. If lordship dismisses it, I cannot stop, my lord.
No, there is no question of stopping or not. Here question is first we'll have to answer your locus and might have to comment on the inquiry report because your whole trust is on the inquiry report. So better you withdraw and go to the court.
No,
This is not the,
one line. I'll just
Yes.
for
Yes.
my satisfaction.
yes, it.
It is on record. I can show it from the record that the lorazepam injection ought not to have been.
Was there.
Yes.
Now, under what circumstances lorazepam is given, whether exceptions are there, they will call in the consumer forum the expert, not only this doctor. He will be put that this is a lorazepam, this is the medical literature. Lorazepam cannot be given. Now, doctor may say, no, there is an exception done in research so and so.
No, my lord.
These are the
The
disputes.
Medical Council of India, while
Understand
regulation,
the medical literature, that's why consumer court. Medical literature is not that it will be these returns, therefore it is then. They will give 100 explanations that this is in circumstances when there is no way that lorazepam is to be given. Then what will you do? Can we decide here? This is not the forum. It's just someone think over it. This is not the forum. Okay. Yes, you want to show us lorazepam. Yes, where?
my lord will see it is medical regulation, my lord, 94, page 94.
Yes.
I have marked it, my lord.
Hmm.
Prohibited list, lord, you can see there.
Hmm.
And RMP providing consultation via telemedicine cannot prescribe medicine this list. These medicine have a high potential of abuse and could harm the patient or the society at large if used improperly. Medicine listed Schedule 10 of Drugs and Cosmetic Act and rules on any narcotic and
No, that, where is the lorazepam?
lorazepam is in that list, my lord.
Where is that?
Lordship, may I?
I'm at page 94. These
Page
two
90
marks prohibited list.
The prohibited list is the Schedule 10 of the Drugs and Cosmetic Act.
Okay.
Any medicine listed in Schedule 10.
Okay. So,
Lorazepam
in the
is
Schedule 10, lorazepam is there.
Yeah.
Now, where is the
lorazepam is entry 66.
entry 66? Now, you tell us where is the lorazepam prescription?
Prescription, my lord. There is a report, my lord.
Where is the report? That report that we have read it.
Yes, ma'am.
I have
It is
not
there
seen
in-
any lorazepam. That is cefotaxime,
that is a antibiotic.
antibiotic.
No, that is not. Hereafter, my lord,
My lord,
there.
lorazepam, that has been administered. It is apparent from the statement of the concerned doctor. My lord. He
Where is
also-
that?
That page 82 in my petition 82.
And kindly see is page 45. In page 45, first paragraph also.
And he also administered the drugs under compelling circumstances. Over telephone, he was advised.
Who advised? This Jain.
Dr. Jain.
Okay.
That can lordship can see at page 45, second line.
Page 45.
No, it will Second line. He then had telephonic discussion with Dr. R.K. Jain, and as per his advice, injection lorazepam 15 unit was injected to the baby at 10 feet. After the administration of this drug, the convulsion starts to the baby.
But your lordship may be right that, my lord, there may be exceptional
We do
situations.
not know that is
because
because
that
and
situation
whether
was
that is the
exceptional.
cause of the death was lorazepam
Yes, my lord.
or COVID, who knows that? Any
my lord.
postmortem
At
report
that point
that
of
is to
time,
be determined by the consumer.
at 10 p.m., my lord, that was a compelling circumstances, my lord. That was a
No, who knows that it was a compelling circumstance?
That is the issue.
But
Who
the
knows that
doctor-
this is
yes,
compelling certificate?
Doctor generally
Who will determine? Who knows
apparently-
that this is a compelling situation? That
No,
may,
no, no.
may be a compelling, may not be a compelling.
So my lord will appreciate. When it is on ethics that that medicine should not be administered over telephone without examining the baby by an expert. That is where the negligence lies.
That is where the consumer court will decide that there is a negligence.
That's it. I bow down to your lordship's finding, but
What is the option now?
option I have to withdraw because if lordship gives the
No, because you want to pass an order, we'll pass
so
an order.
lordship if
So
lordship
don't think that we have compelled you. We'll dictate
No,
an order,
no,
not
I
right
will
now.
not take
We'll-
the risk. On one hand, I cannot dictate your lordship. On the other hand, if there is a adverse remark, then my consumer case will go.
Because you'll have to comment on the inquiry report. Because your whole case is that this is the inquiry, these are the finding of facts. On the basis of, because Reed Court's judicial power will be on these admitted facts.
অসমীয়া লেখাৰ কথা আছে, অসমতে নাম থব লাগে।
Mr. Samuel learned counsel for the petitioner prays that he may be allowed to withdraw this petition.
After a threadbare argument, lordship will say,
Learned counsel for submits that he may be allowed to withdraw this petition and to approach appropriate forum seeking redressal of the grievance.
I'm obliged. I'm obliged. Lordship, please to call for check. Yes. Lordship,
Yes.
recorded.
Okay, call. We do not know. Your act says, do this within this period. If it is not done, April, yes, madam. We want the instruction at 2. Or personal appearance, either way. Yes.
Mayfield.
Yes.
So in fact, in this case, what has been done by respondent PN4?
Yes. Who represents the municipal? PNRD.
The name has been shown. My lord, in fact, there was a direction on the earlier, my lord, proceedings. By the
That agreement is not executed.
not agreed. But what has been done to circumvent that order? Now an encroachment case has been registered. My lord, under section 18 of the Assam Land Revenue Regulation, the property in the land belongs to PNRD. And if I'm not mistaken, those, my lord, 18.
That they want to demolish and reconstruct a market where you want an assurance that I should be given a room.
Correct.
Now, where is the question of encroachment? Who will represent him?
Not a government property, government land, my lord. Now to.
Yes, who is?
I am for the PNRD.
Yes. Do you want to stay whole of your development project that you want to construct a market?
In this regard,
If
instruction
you
is
want
needed
that, we'll clarify that. This is the situation. That's why we are compelled to stall a public project. Yes.
Lordship, in this regard, Lordship, instruction is needed, Lordship.
Huh?
Instruction is needed, Lordship.
Instruction have it at 2.
Lordship, Lordship, can
At 2. This is not the way. There is a specific order that these people are there. There is a findings in the market. Now you want to demolish that market and want to construct a new building. Okay, fine, very well. That is required in a village. Court directed you enter into an agreement and incorporate a clause that you will assure him to give a room. You have not executed. Now you raise an encroachment. Will stall whole project. And the cost of escalation and everything will be on those persons will have to give. Have your instruction F2.
Right.
$15 and same. 50, 60.
May I please be heard?
Hmm?
The petitioners are aggrieved by an order, your lordship, at 20 page dated 23 to 2024, your lordship.
Where is that?
That is, your lordship will get it at page 55, your lordship. Now, these are, your lordship, under a scheme called Petition, your lordship.
We understand.
Lord. Now, the problem is this, your lordship. For 4 years, they are not paying us, number one.
Hmm.
Number two, the house, the buildings, your lordship, are taken on rent by us, your lordship.
Hmm.
Now, infrastructure, your lordship, is substantially created by us, your lordship. Without settling all those, your lordship will kindly, we are aggrieved by these words, your lordship.
Where?
It page 55. It is to be mentioned there that all existing Shakti Sadan currently being operated by NGOs may be continued up to 31st March 2024 and will be taken over by Gov with effect from 1st April 2024. Therefore, you are requested to complete the formalities of taking over the existing Shakti Sadan with the concerned implementing agency of your district within 31st March of 2000 as is where is basis, your lordship. Without settling our dues, your lordship, there cannot be any, we can use these buildings for our purpose also, your lordship. As is, where is basis means, your lordship, I will have to hand over everything to them, your lord. That cannot be. And
You make an assessment
lordship.
that this is the cost, this is the amount. Yes. When? Have the instruction.
But next week, subject to the convenience, on a report, extra copy.
Extra copies will give. We are not issuing a notice at this stage. We want an instruction.
Yes, sir.
So that because there will be a question of an interim order.
Yeah.
Now, moment we pass an interim order, that will amount to stalling a process of a policy of government taking over the entire project. This is one of our, will not like to stall the entire project. At the same time, we will have to balance that what will happen to this. You cannot come and say, throw them out.
Unless we clear the due.
Yes, unless you clear the dues or you have a policy that this they have done, this is the due. Because it's like an handing over. If it's like a liquidation, you want to take over. That's all.
Only thing, my lord, if they would be more clear about what is exactly due to them.
That
If they furnish.
no,
my lord.
that furnish, that before that you will have to say that we will pay. Are you saying that on behalf of the state?
I will.
That you will need the instruction. Moment you say that, then the second thing will follow. How to be ascertained. If you are saying that no, we are giving it, then we'll go for that. How it is.
Everything has to be verified.
Mr. Borthakur, learned counsel for the petitioner. The petitioners are NGOs and are running some
Shelter home for women.
shelter home for women sponsored by Ministry of Women and Child Development, Government of India, namely Shakti Sadan. The petitioner, according to the petitioner, they have developed the centers and invested huge amount of money, and a substantial amount is still unpaid to them. At this stage, the government, by the impugned decision dated 23rd of February 2024,
Lord.
2024, has taken a decision to take over all these centers, namely Shakti Sadan's being run by the NGOs run as is where basis. Mr. Borthakur is aggrieved by the condition as is where basis, inasmuch as it is the contention that without paying the dues to the petitioner and without ascertaining the value and giving a right to the petitioner to retain the rented premises and their properties, the government is not empowered to take over the suddens in as is where basis. Accordingly, he prays for an interim order. As the government has taken a policy decision to take over these suddens, this court, before taking a call on passing an interim order, would like to have the instruction from the government as regards claim of the unpaid claim of the petitioners, an unclaimed paid claim of the petitioners, and their right to continue in the rented premises with the properties acquired by them. Full stop. Please this matter on, because it is 1st of April, you are starting 27th, 27th. Full stop. Huh? 27 March. You want the pensions to be stalled, huh? For a person that his case, criminal case is
Yes,
pending.
Your
Who is he?
He's a social worker, the petitioner.
He could have been there, would have been imposed him a cost. He knows that. That's why he's not here. Yes. Yes. How this repetition is maintainable? Forget about division bench. After Suryadev Rai, it was referred to a larger bench where it is specifically stated that no, what is the judgment? It is said that no writ petition under 226 against a judicial determination. Past order passed by courts and it will be 227. It's clear judgment. No. What is a simple? It's not a from you to file such kind of petition. By my Lord Justice Goel. Forgot the name of the judge. Radheshyam. Withdraw, file a fresh petition. 227. Hard. Mr. A. Ahmed, Learned Counsel for the petitioner. The present petition is filed under Article 226 of the Constitution of India, assailing an order dated.
Page 56,
Huh?
12, 2010. Page 50.
Page 56. Order dated 6/12/2022, passed by the Learned Motor Accident Claims Tribunal, Gwalpara, in MAC case number 190 of 2018, whereby the claim petition preferred by the petitioner was dismissed, isn't it? And application for restoration. Not made. Was dismissed, rejecting a petition for adjournment. Okay. Full stop. In the case of Radheshyam and another versus so reported in so. The determination made by the Honorable Apex Court in the case of Surjadev Rai versus Ramchandra Rai reported in 2003 3 SCC so. It was held that the application under Article 226 shall not be maintainable assailing an order passed by a court or tribunal exercising its judicial power. Full stop. That being the position, Mr. Ahmed submits that he may be allowed to, in view of such condition, the present petition is not maintainable. However, considering the nature of litigation, it is directed that the present petition be converted into an application under Article 227 of the Constitution of India, registry to do the needful, and the petitioner is allowed to, or better you file a refresh. Accordingly, petitioner is to withdraw this application or file an appropriate application under Article 227 of the Constitution of India. PR is allowed. Problem. Page 67. Page 6. Yes. 2003 3 SCC 67. Problem. Have you gone through?
Yes.
What is the
The records reveal that the deputy commissioner received complaints regarding certain shops that the evaluation has been improperly done, not the shops in question, definitely not these shops. So instead of directing a re-evaluation limited to those shops, he directed a district-wide re-evaluation. So on the basis of that, a re-scrutiny was done, where unfortunately the shortcomings were found in the bids of the petitioner officer.
now, if that be so, suppose we hold that, okay, that's now, is there any scope for evaluation? This is first. Okay, we assume that they are having a power for evaluation. There may be complaint, there will be malpractices. We will not say that tendering authority is powerless to revisit their decision for the time being. Then question will come in first case. What is the ground in second case? Same.
Same ground.
Same.
No.
Now, you want that this person should have an account. Okay. And for that purpose, you in the tender first, you specifically say that these documents are required in the notice. That does not include a proof of bank. No, we'll come to it. This is the tender direction in the tender condition.
Yes.
In the tender condition, it is said that these are the documents the tenderer will have to annex. Specific. Where this proof of bank account is not. However, in the form,
yes,
there is a distinction. You have a tender condition which you make some essential document which is to be taken. Now, in form, you give in certain clauses that proof is to be given. Now, proof means what?
Proof of that particular bank account.
Proof of that particular bank account. How the proof will be there?
What I have seen other bidders, your lordship, they have given either check or some have given certificate with the specific account numbers.
Okay. Suppose a certificate, passbook also. A certificate you have not qualified or qualified. What should be the proof of a bank account?
That
in this case, there is overwhelming materials of having a bank account because you want him to have GST, you want him have to the income tax return, you want to have him a certificate from the bank that solvency. In that certificate, bank says he is having this account, he is solvent.
The bank
So
certificate.
let us stay it for the time being and decide it on a
Lordship,
proper day.
one aspect, Your Lordship, the certificate, yes, that is just what the certificate.
So it needs an examination.
The certificate perhaps does not say that, Your Lordship, because one aspect the petitioner
Perhaps, but there is overwhelming materials.
Lordship, rather than saying it, Lordship will, because the letter of award has been issued, Your Lordship,
Ah.
they have already deposited that license fee. The Lordship may make it subject to the outcome, because the petitioner has also approached very good.
See, they will invest wastage of time. They have on what they have done. They have only deposited, and it is what? It is only alcohol. It will not hamper the society, not giving. It's not a school that we are stalling. It is alcohol, and it is only 2 shops. You have allotted how many shops?
This is regarding, because Your Lordship, if your
It goes a little bit walk for a kilometer.
Your Lordship is not holding anything regarding the re-evaluation there, because otherwise that will have a district-wide.
That's why
Yes.
a re-evaluation, we are more or less, because they are the bidder. They suppose there is a fraud. The committee has committed some illegality. Will that employer will not be within their jurisdiction to revisit?
That is there.
So if that is there, let us consider it in that context.
Lordship may fix a date, Your Lordship, for hearing, and till then, Your Lordship, let us for us.
When?
Lordship may, otherwise.
Very short,
because
very short.
much
Today may not be possible, being a miscellaneous
Since
day.
the model code of conduct is going on, we can also take advantage of that period, because otherwise also license cannot be issued to them during this period. So for
Okay,
us,
anyway, we'll clarify whatever the position. We do not want to have them have a house and this, that, then issue complexities. Give a date.
It's a court of appeal.
Huh? Ah.
Court of similar.
Okay.
Then
we'll
court
file our affidavit, Your Lordship, on this
Okay.
condition, whether it is. How we have
Okay, we'll pass this order because it's an interim order. We'll just elaborate our point and pass this order for status quo as on date and fixing it on 4th of April, issue a notice. Mr. Agola, you are accepting? Mr. Give slip of who are appearing for. I think that will be better option. Nothing will decide on the next.
Lordship may only indicate that that perhaps the matter can be taken up for disposal at an early date. If that
No,
is the case,
since we'll observe it, since records are available, an endeavor shall be made to decide
or
this
Lordship
matter.
will file our affidavit, because the records that have been provided to me, that applies to the district-wide selection.
Okay.
If I retain the records, the entire selection process.
Okay,
will
you
stop.
file an affidavit.
Very well.
Parties may exchange pleadings
Very well.
in between.
obliged.
Deeply obliged. Both discussions. In the second case, he has given and okay. Just a minute. Yes. Yes, Mr. Kusit.
Mulaj, I'm grateful, Mulaj. Well, just two important points, Mulaj. Here is a case in which a certificate that was granted by an appropriate authority is sought to be cancelled. And as your lordships have just been told, an
Cancelled
affidavit
already.
saying that it's been cancelled. Lords, now I just our mainstay, and as your lordships know this well, Madhuri Patil is the basis on which this procedure is followed. And if there is a violation of that, then of course, my lords, your lordships will reflect upon that. My lords, if your lordships would give me 2 points. One is to look at just 3 paragraphs of Madhuri Patil.
Madhuri Patil.
Because we had given copies of the judgments that your lordships will be concerned with. My learned friend there will make them available.
So the file one copy there last time. Not right.
Because this is 1994 6
Ah.
SC 241.
Okay, Madhuri Patil.
So, my lords, the paragraph 13.
Paragraph?
13 is the critical paragraph. That's the operative paragraph at page 254, paragraph 13. And I'll only read three sub paragraphs of paragraph 13.
Yes.
If your lordships be good enough to come to 4, paragraph 4. Well, this is the backdrop that all state governments shall constitute a committee of 3 officers, etc., etc., and another officer with intimate knowledge of verification and issuance of social status certificates and so on and so forth. This is the backdrop of what is to be done in every state. In paragraph 5 minutes, each directorate should constitute a vigilance cell consisting of senior deputy superintendent of police in overall in charge and such number of police inspectors to investigate into the social status claims. The inspector would go to the local place of residence and original place from where the candidate hails and usually resides, etc., etc. So, my lords, the vigilance committee, I'm not going into the details of vigilance committee and the scrutiny committee, but the vigilance committee is required to go into the local area, etc. My lords, now it follows with paragraph 6 and 7. But if your lordships will permit me for a moment, I will go to 7 first and then come to 6.
Okay.
So 5, the vigilance committee has to go and make necessary inquiries, etc. And then submit the report to the directorate. My lords, now paragraph 7. In case the report is in favor of the candidate and is found to be genuine and true, no further action need to be taken where the report or the particulars given are procured or found to be false or fraudulently obtained, and in the latter event, the same procedure as is envisaged in para 6 to be followed. So, my argument is that a report was submitted. The report said that the complaint itself was wrong, and therefore the report was final. That final report was submitted, and that would be final, and paragraph 7 would automatically apply. Now, my lords, on the other hand, it says, however, if there is misrepresentation or fraudulent element, etc., then it goes back to paragraph 6. In those circumstances, what is to be done? Paragraph 6. The director concerned, on receipt of the report from the vigilance officer, if he found the claim for social status to be not genuine or doubtful or spurious or falsely or wrongly claimed, the director concerned should issue a show cause notice, supplying a copy of the report of the vigilance officer to the candidate by a registered post with acknowledgement due or through the head of the educational institutions concerned in which the candidate is studying or is employed. Well, at that point, obviously the Honorable Court did not have in mind that this would apply also in cases of candidates who are in reserved category, etc. But the generic requirement is whether it is for educational purposes or it is in the case for job, and now in our case, or it is for purposes of filing in a reserved constituency, the same generic principle will apply. A report found to be correct will have to be closed at that stage, nothing more. No review, no appeal, etc., as far as things stand today in Madhuri Patil. It's a different matter as in Maharashtra, they've made some rules. So if there are some rules, well, as the Supreme Court has clearly said, then the rules which will fill the gap will be...
Because it was said that till Madhuri Patil's decision was until legislative action is taken.
Absolutely, like Visakha.
So when in Maharashtra that 2000 rule came in,
quite
so
right.
therefore Supreme Court says that okay, now no rule of Madhuri Patil that enactment by legislature will follow.
But as far as we
But
are
in our case, there is no legislation,
no rules, there's no
There's an administrative.
administrative action, and in terms of Madhuri Patil.
Right,
Yes.
I'm deeply grateful. Now, my lords, the issue here, as your lordships will see, is that there is nothing that leads to paragraph 6 in the report that was submitted. Now, I'll bring your lordship to that report in a moment. There was nothing in the report that brings us to paragraph 6. And if paragraph 6 is to be applied, then the question is, on what basis is paragraph 6 being applied? My learned friend on the other side has an argument, which is that there was the first report, which was in my favor. Second report is not in my favor. But my learned friend's arguments, as I understand, is that this is a continuation of the first report. And therefore, you have to take it in totality. The first report is the preliminary report, and this is the final report. There is no such provision, my lords, as I've read the paragraphs, there is no such provision as far as Madhuri Patil is concerned. And then the backdrop of this is, my lords, that this is not a question of a de novo inquiry or investigation. This is a case where in 2011, a certificate by the appropriate authority was issued. That certificate got challenged during the process of the election petition. Election petition was disposed of at the stage of the Supreme Court, and saying that you haven't really gone to the root of the matter, you've not challenged the certificate, you are just saying the certificate is wrongly given. That in a collateral proceeding cannot be done. It cannot be done in an election petition. You have to challenge it from the root itself. Now that challenge, my lords, had been made. That challenge had been made, but that matter was withdrawn. It was not taken to a logical conclusion. The matter was allowed to be withdrawn as being infructuous, and it was withdrawn. So today there is no judicial finding, my lords, that the 2011 certificate is not a valid certificate. Today there is no adjudication, no judicial finding. In circumstances such as these, would not Madhuri Patil procedure require somewhat greater scrutiny, because it is not just a matter of de novo deciding whether somebody has the right community or caste, but actually having been decided, the actual challenge to that is coming through the SLC, which is perhaps something that the SLC is not in a position to do, because it is only if the certificate was set aside in judicial proceedings that the scrutiny committee could then proceed to say, now investigate and find out what is to be done. But that certificate is set aside as a consequence of the scrutiny committee's order, speaking order. It is not set aside as a consequence of adjudication through a proper judicial procedure. That is a critical point that I would underscore for your lordship. Now, my lords, one last paragraph in Madhuri Patil.
Do you propose to say that until and unless there is a judicial direction or any dispute in a judicial proceeding, the SLC will not have the jurisdiction as has been done on the basis of a complaint filed by an authority?
I'm grateful, my lords. SLC does not have the power to review any
That we
dispute.
understand. According to you, the first report filed by the some officer, CID officer, vigilance, we do not know, we'll go to details. That being in favor of the petitioner, the SLC could not have proceeded for a second review because that is barred, or that procedure is not prescribed under paragraph 7 and 6 of the Madhuri Patil.
Very great.
Paragraph 7 and 6 of Madhuri Patil.
Very grateful. My lords, that's the gist of my argument. Now, if your lordships would want to see the concerned reports, my lords, if I may show to your lordships the concerned reports. The first one, my lords, if your lordship will just look at the background from page 58 of the petition.
Paragraph?
My lords,
Yes.
Page 58, I'm just showing the document concerned, my lords, at page 58. Annexure Annexure 9.
Yes.
So, my lords, the complaint was made on 11/6/2019, 11/6/2019, and that your lordships will find at page 48. But on the basis of that complaint, comes this at page 58. 58? At page 58, and your lordships will see this is of 11th of July 2019. In enclosing herewith a petition received from Shri so-and-so as directed to request you to kindly inquire the caste status of Shri Naba Kumar Saranya, Honorable MP Kokrajhar HPC, through your Vigilance Committee, and submit an inquiry report to the State Level Scrutiny Committee for caste verification. Well, lords, as I said, this is de novo. Somebody complains and says this person's caste has to be verified, decided, etc. But it is not about the cancellation of a certificate that has been granted, and there is no argument here that the certificate was given fraudulently, and this certificate therefore must be cancelled. There is no such argument here. Even if there was such an argument, as your lordships have rightly observed, my argument is that it has to be done through a judicial process and procedure. It can't be done in a de novo exercise by the Vigilance Committee on behalf of the Scrutiny Committee, because the Scrutiny Committee is not in a position to take a view at that stage. Well, it's when the Scrutiny Committee takes a view which is adverse to the interests of the person concerned, then the Scrutiny Committee gives a speaking order and issues a show cause notice. A show cause notice that explains to the person what that person is up against, and the person can then place whatever that person wants to place, including an oral hearing and cross-examination of any witnesses that have been cited as the basis for coming to an adverse opinion about that person's caste. So, my lords, this is the structure in which this decision has to be taken. Now, nothing like that was done by the Scrutiny Committee. Simply a letter was sent to the Vigilance Committee to make an inquiry, etc. Nobody was told, the Vigilance Committee was not told, please inquire whether the certificate was wrongly granted. But they were saying, go de novo inquire whether this person has the right community or right background, ethnographical background, etc. So, my lord, this is the backdrop in which this happened. Your lordships may go directly now to the report that was submitted, and that's at page 63. Rightly or wrongly, this request was made, and a report of the vigilance is submitted on 23rd of October 2019, which is at page 63. If your lordships will see right on the top, it says furnishing of inquiry report. There is no preliminary findings, etc. This is the furnishing of an inquiry report. And your lordship will see giving the narrative of what they were required to do. At paragraph 2, your lordships will see, for verification of caste certificate of Naba Kumar Saranya, I visited the given address, examined the persons noted and other prominent persons of that locality, and found that the said persons belong to Saranya Kuchari community, which is under the purview of STP category. In this regard, I collected a copy of letter by Government of Assam, Department of Welfare, Plain Tribes, etc., dated 15th of June 2018, addressed to all deputy commissioners and so on and so forth. Well, this letter of 15th June 2018, in candor, I must admit, has subsequently been withdrawn. This letter has subsequently been withdrawn. And if your lordships would know that it's clearly accepted that Sarania community, if there is such a community, does not have tribal tribal status. Sarania is a name that is used by tribals, particularly of this area, who have converted to Hinduism but have retained their tribal attributes.
Who have taken, you call it Saran.
Saran, they've
Saran
taken
under some Vaishnavite, it's
that-
not
that
kind of a
Vaishnava.
Hindu.
I'm so
There it is a acceptance of Vaishnavite culture. So
I'm so
therefore, Saran.
And it is, as I understand, my lords, and your lordship may take judicial notice of this fact, that it is only tribals who take Saran, and tribals who then therefore call themselves Saran. And that's how it's happened. My learned friend who's arguing with me in this matter is also a Saranya, but he's a Boro. So interchangeably, the terms are used: Boro Saranya, Boro Kacharia. Now, Boro Kacharia are included in the tribal list. Kacharia are included in the tribal list.
Imakasar is there included.
Boro is, yes. But what is not included is Saranya. Saranya is not included. Apparently, there are some proposals, etc. But that's neither here nor there at present. But so the question really is, by adding the word Saranya to your name, which is being done largely by people of tribal background who have taken Saran, as your lordships have rightly said, and those who use the word Saranya, would they lose their tribal identity? And the judgments do not go anywhere near this at all. So the question is, whatever was to be decided in this vigilance report was, as your lordships will proceed further down to the last paragraph, in course of inquiry, it is found that the complaint lodged by the civilian, namely Miss Fatima Khatun, Jarak Lal Basumotri, and so, is not genuine. The incumbents noted belongs to OBC, STP, and OBC respectively. Mr. Azizul Haq belongs to OBC community. There were three people who
Because this report relates to three people. Second is Saran, the petitioner Karin.
The
he
last
relates to, according to STP, others are OBC and something.
Quite right. And then Shri Naba Kumar Saranya belongs to STP community and so to OBC community. The complaint submitted by the aforesaid persons before the director of Assam is based on no truth. In all fairness, my lords, I would say that this report hasn't also gone into questioning the actual certificate that had been granted, to say that there was any fraud or there was any problem, etc., but have just upheld what the certificate actually said, that Saranya, that this gentleman is a tribal. That is what is, as far as I'm concerned, my lords, this is the end, and this is all that is needed in paragraph 7 of Madhuri Patil. Nothing further can be done. Of course, courts have clearly said that 2 to 6 is available. You can go and challenge it in a high court. There is no problem at all. You can challenge it and get it struck down. You can get the certificate struck down and made and voided. But it cannot be done by way of a review, and it cannot be done by way of an extension of an inquiry. So, my lords, in all fairness, I must come to the second report.
Now, what happened after this report? How the second report was initiated?
After this, at page 665, your lordship will see that the vigilance committee was told, please go and look at the revenue documents, go and look at the land records and land documents to give us more information, etc. Is that the power, I ask myself, my lords, is that the power that the SLC has to ask for a further inquiry, to ask for more information? Certainly not as far as Madhuri Patil is concerned. And in any case, whatever they were asking for would amount to a second report, and in the power to and jurisdiction to seek a second report is not available. As I said, all that is available is power under 2 to 6, and that's what could have been availed of by the parties concerned. So, my lords, if your lordship will kindly come to page 65. Page 65, the fresh inquiry.
Yes.
Now here, lordships, now here it says submission. This is 25th of October 2019.
Yes.
Yes, my lord. So, in enclosing here with a copy of the complaint petition submitted by Shri So-and-so, I'm directed to inform you that the Committee on Welfare of SC/ST Assam Legislative Assembly will take a meeting on 7/11/2019 to discuss the case status of Shri Naba Kumar Sarania. You are therefore requested to submit a caste status report on Shri Naba Kumar Sarania, taking into account the documents relating with his land and legacy data to this department immediately. So this is not even a second inquiry. This is an independent inquiry for purposes of informing the Assembly as to what is the background of this. So please look into documents of land and so on and so forth, and then submit the details to us. Then, my lords, what is submitted, your lordship will find at page 66, which is dated 6th of November 2019. Subject is submission of caste report.
Yes.
If your lordship will see what they provide here is third line, as per the report submitted by the SDO Tamulpur subdivision, Baksa, etc. enclosed, the father's name of Shri Naba Kumar Sarania was recorded as Lakhi Zoro Kosh in land documents and as Lakhi Kanta Zoro Kosh in NRC related documents. So just out of the blue, they are told, please go and find out. And they say the father's name was recorded as such and such. No further inquiry, no further questioning as to why it was recorded as it was recorded. Then, my lords, if your lordship will see the page 67.
Yes.
Page 67, your lordship will see the same thing is repeated. That Mr. Sarania's father's name is recorded as Lakhi Zoro.
This is the type copy of, I think, report of the circle officer.
Well, lords, this is to Deputy Commissioner Baksa. Yeah, report from the additional commissioner. But your lordship will just see the 3 lines at the bottom. The caste certificate was issued to Shri Naba Kumar Sarania by all Assam Tribal Sangha Tamulpur district unit, was duly countersigned by the office of the undersigned, etc. So they've just given some facts, not related them to the certificate, and said that I countersigned the certificate. It was given by the authority concerned. Then, my lords, the second report your lordship would like to see at page 74.
Yes.
Page 74, my lords. This is annexure 17.
Yes.
Your lordship will see here, this is again submission of inquiry report.
What is
Inviting,
that 37/2019 in reference to
well,
numbers?
that would be the letter. I will just tell your lordships in a moment. That would be the letter by which they were asked to look in this. At page 59, I'm told, my lord. That's at page 59.
Page 59.
So those 3 names that would have been referred, your lordship will find at page 59.
Okay.
So that's the continuation.
Okay. Page 59. Yes. Yes.
So, my lords, your lordships are May I invite your lordship?
I'm at page 59.
50
Sorry, page 74.
74. Your lordships are grateful 74. Then, my lord, your lordship will see they were asked ancestors, caste status, legacy data, verification, land documents, admission report in educational institutes, etc. Then the steps they were taken, etc., etc. The complainant also produced the following documents. Then paragraph 2. The office of all Assam Tribal Sangha Tamulpur unit was visited on 29/2009 to check available official records pertaining to the inquiry. The available records were checked and scrutinized in presence of the staff. So they would have seen that the certificate issued to Sri Naba Kumar Saranya is enclosed herewith. General Secretary of all our Sangha said whatever, etc., etc. Then below 76. Paragraph 6.
Yes, I visited.
So, my lord, this begins the story against me. I visited Tamulpur Government MB School where Sri Naba Kumar Saranya studied up to class 7. As per available records, he was a student of school till 1982. Admission records and other school records were verified in one class 7 admission register for the year 1982 in serial number 59. The name of Sri Naba Kumar Saranya was entered as Naba Kumar Deka, son of Lakhi Kanta Deka, etc., etc. And then this continues, my lords, Das is mentioned, Deka, Das, all these titles that are variously used by people, those titles are indicated. Paragraph 7. Following witnesses were names given below were examined and their statements were recorded. Gambora Shri Ramin Raba, Shri Suresh Raba, Shri Sabha Raba. Statements of the above witnesses have been enclosed in annexure so-and-so. I visited DC office and collected NRC legacy data of late Shri Lakhi Kanta Sarukoch. Now, another name is used, Sarukoch, etc., which is apparently, as I am briefed, that's not a name that exists formally. And your lordship will be good enough to come to the findings.
Findings.
In other words, from the copy of official letter forwarded, etc., from Tamulpur division, it has been found that the concerned officer had stated till receipt of direction from authority in this regard, the process of countersigning of Saranya people shown as Raba or Boro Kachari is kept in abeyance. Then paragraph 2, copy of affidavit of Srimati Vinita Pegu. The deponent clarified by saying that the deponent begs to state that Saranya Kachari has not been enlisted in the ST list of Assam and as per Scheduled Caste, Scheduled Tribes order as amended from time to time. My lord, there is no issue there, no cavil with that at all. It hasn't been included, and therefore we don't need to rely on that. Paragraph 4. In order dated so-and-so, in the writ petition, the Honorable Guwahati High Court has observed that Saranya is not enlisted tribe in the list of scheduled tribes incorporated in Central Order number 22 through tribe certificate has been issued to Sri, though tribe certificate has been issued to Sri Naba Kumar Saranya. Further, the Honorable Court also ordered the all Assam Tribal Sangha to issue tribe certificate only those persons following in the categories listed in the Central Order number 22. So there is no issue there at all, my lords. 5. Lordship will see the third line. The certificate was issued in the name of Sri Naba Kumar Saranya, son of late Lakhi Kanta Saranya, address, etc., etc. District as a Boro Kachari. Boro Kachari is a tribal. Saranya is not. Saranya is used by tribals, is a consistent case. Then, my lords, this, your lordship, will come to paragraph 7. This is, in her statement, Srimati Deepika Das stated that it has been around 26 years since her husband, who was working in military, expired. She said that she has 6 children, 3 sons, 3 daughters, and all of them have caste certificates. She further stated that she has no caste certificate of her own, as there was no requirement of caste certificate at that time. She also said her husband had no siblings, and he wrote Das as his title surname. Srimati Dipunta Sarania 8 is a sister of Naba Kumar Sarania, stated that she is working in a beauty parlor and stopped studying after passing PU from Tamilpur High School. She further stated that she has STP certificate and that she and her family belong to Sarania community, and her father used to write Das as his title. So Das, Deka title that's used does not affect the tribal attributes. In my lords, if your lordship will just jump over 3-4 lines and then come to the conclusion. From the above facts, it can be found that Shri Naba Kumar Sarania and his family were using titles Das and Deka, which do not fall under the category of Boro Kachari. Of course they don't. But they were Boro Kacharis. Well, that was the critical thing. And well, then they move on to talk about the if your lordship will come to paragraph 12. The last 3 lines on that page, my lords, on page 78, last 3 lines. This is about Raman Raba, the Gaon Bora. He stated that Shri Naba Sarania was born in Digalipur village. His father's name was late Lakhi Kanta Das, alias Sarakosh. His father expired around 25-26 years ago and working as in Assam regiment. His father expired during the accident which working in the Assam regiment. The name of Shri Naba Kumar Sarania's grandfather was late Sela Ram Das. They are originally from Dighalipur, as both of the grandfather and father were born there. Naba Sarania's family actually belonged to the Kosh community, who became Sarania after taking religious saran. The mother of Shri Naba Kumar Sarania is Srimati Deepika Baladas, whose marriage was conducted based on mainstream rites, traditions, etc., and not according to traditional rites, rituals of the Boros and Rabas. Then the NRC legacy, lords. Then I just bring your lordships to page 80. Taking into 80, my lords.
Yes.
Taking into consideration the practice of Boro Kacharis to use surnames peculiar to the community and related to nature, such as Basumatri, earth folk, Narzari, jute folk, Daimatri, water folk, Ishlari, god folk, etc. The claim of STP certificate by an individual whose title surname is Das as Boro Kachari leads to suspicion. Moreover, the statement of government Gaon Bora Shri Raman Raba that the marriage ceremony, etc., of parents was not conducted according to traditional rites further gives credence to the contention that Shri Naba Kumar Sarania and his ancestors are not tribals and that they do not belong to the Boro Kachari community. Scrutiny of admission register, etc., for the year 1982 has revealed the name of Shri Naba Kumar Sarania was written as Shri Naba Kumar Deka, son of Lakhi Kanta Deka of Digalpur, entered, etc., so and so. Then, my lords, the last paragraph there.
You say that these are kind of an affinity test.
That's right. These are cases where interchangeably people have been using.
So is it your argument these are kind of an affinity test which is not permitted always?
That's right. Your lordships are obviously so well versed with all these cultural features that we find ourselves a little bit inadequate in terms of the knowledge of your part. Yes. But Lord, the affinity test, of course, I have to add, is not conclusive proof that your lordship knows very well. But here there has been a jumble of names that have been used. But the critical thing has come when I filed my reply, and I said that you didn't take any senior person from my village. Everybody in my village virtually uses the name Saranya. Everybody. You didn't take any serious senior people who have knowledge, etc., who would have said that we all use Saranya and he also therefore uses Saranya and we are all part of the same community. Nothing of that nature was done or attempted. Just these general findings, and then they've said that because of these general findings, so my lord, if he was Kosh, my lord, if he was Kosh, he would still be a tribal. As a Saranya, he can't be a tribal. As a Kachari, he'll be tribal. As a Boro Kachari, he'll be tribal. Now, my case is that I am actually a Boro Kachari. That's my case. Now, nothing is being made out here to show that you are not a Boro Kachari. Simply by saying your father used a title, Deka or Das, etc. Therefore, when you were admitted, your name was also put down as Das or Deka, etc. But no critical, crucial evidence has been provided to say that all this is sufficient to negate the giving of a certificate in 2011, which certificate amounts to a fraudulent, misrepresented certificate, which has to be set aside. Of course, in a court of law, all these matters would be considered, examined, and the court could come to a conclusion that no, having examined everything, this certificate has to go. But not on the say-so of a vigilance officer who goes to inquire almost as though he's being told you go and find these things, and so that you can come up with a report that will negate the first report that is being filed. I think that is something that is not permissible, Malaj. Similar, if your lordship will see, once this report was submitted, then my lords,
any conclusion by the inquiry officer?
My lords, the conclusion by the inquiry officer, if your lordship will
He has narrated what are the facts, what is his finding, what he has gathered. What is any conclusion on his part? No.
Then, my lord, there is something here. If your lordship will go back to page 84.
It is page 81, I think. Which
84.
shows that the parents of Navakumar Sonoria were not Boro Kasaris.
No, what is this page?
This is 84. There's a show.
I see. So, my lords, no, where is the finding? So, my lords, at your lordships are right, page 81. Having given all these facts, etc., about subclass and so on, moreover, the interchange of titles, surnames, Das, Sir Coach, Deka, Sarania, Vaishri, Navakumar Sarania and family is another cause of concern. So, what is found is a cause of concern, something that be suspicious of, etc., but there is no final finding here to say that, look, conclusively, this is what I have found. There is nothing here in this report. And on this basis, a show cause is issued to me. That show cause your lordship will find on page 82, 11/3/2020. Well, may I just point out that all this is to be done according to Madhuri Patil. Well, all this is to be done from a day-to-day inquiry is to be held, and it's to be done within 60 days. 60 days, and thereafter, my lords, the indication is that even high courts or courts would dispose of the matter in 3 months' time. We are talking about the show cause was given to us on 11/3/20. 11/3/20. We are now in 24. We're now in 24. And the final impugned order is passed on 12/1/2024. Your lordship will keep that in mind to look at the urgency with which this should have been done, keeping in mind that they were dealing with an elected MP who would obviously have to move on to to contest the elections again. And yet no urgency was shown except suddenly when the impugned order is issued on 12/1/2024. And then even later, Well, if your lordship will only note paragraph 9 of 13.9 of Madhuri Patil. Paragraph 9. Your lordships have that. Inquiry should be completed as expeditiously as possible, preferably by day-to-day proceedings within such period not exceeding 2 months. And then your lordship will see paragraph 11 as well. The order passed by the committee shall be final and conclusive, only subject to proceedings under Article 226 of the Constitution, etc., etc. And 13, High Court will dispose of these cases as expeditiously as possible within a period of 3 months. So the Honorable Supreme Court was very conscious of the need to have fixed timelines, because there were students who would have to be admitted. There were people whose jobs would be on the line, etc. And here, of course, is the case where somebody has to represent a democratic constituency. And yet, my lords, the lackadaisical attitude. Then, my lords, if I may.
Yes.
Your lordship will see the show cause notice, which is 11/3/2020 at page 82. They've just given the entire background.
They have quoted what we
And
have.
then your lordship will come to page 84. That's important. It gives away what they are thinking. Whereas a discussion on the above points shows that there are many questions of genuineness and doubt about your claim as belonging to Boro Kachari community. The Assam Regiment Center records your late father's caste class as Assamese. Notably, your parents used the title Das before shifting to Saranya. It is also known that any person from any community, tribal or non-tribal, where he or she takes up Saran, religion becomes Saranya. The NRC legacy data, land records, and your school records of 1982 also prove that your parents were either Das, Deka, or Sarakosh. Statements of Gaon Bora of your village and others also say that your parents belong to Koch community. It is also reported that the marriage ceremony of your parents was conducted in based mainstream rites and not according to traditional rites or rituals of Boros and Rabas. No evidence is found to support your credentials as a member of ST community Boro. Whereas prima facie it is found from the report of the vigilance officer that STP certificate issued in your favor is doubtful from different angles as enunciated in the inquiry report enclosed. Whereas in view of the findings of the vigilance officer, certificate is liable to be for immediate cancellation and confiscation. Well, lords, with great respect, whether this power was there or not, I argued that the power of cancellation would not be there because that cancellation would only have to be subject to judicial proceedings. And a prima facie case is found. But your lordship will see my reply that I have filed in this.
Now, where is their final order?
What is the final order? Well, that your lordship will find at page 111. That is 12/1/2024.
Can you file reply?
I filed the reply, and then came this speaking order. Well, essentially, I was not allowed. I was not given a copy. I was not given a copy of the report. I had to get the report under RTI. I filed a reply. I filed an additional reply. I wasn't given a chance to cross-examine any of these people. I wasn't given an oral hearing, etc. Only my reply was considered, if at all it was considered, and then the final order was passed. For something as serious as this, lasting a lifetime, the least I could have expected in terms of natural justice was they would give me a hearing and that I would be allowed to cross-examine people who had made statements. And certainly that evidence of the person who had given me the certificate in the first place should have been examined, but even they were not examined. And my lords will see that the findings are to be found in page 113. Your lordships have page 113.
Yes.
At the bottom of page 113, the STP certificate was issued in the name of Sri Naba Kumar Sarania, son of late so-and-so, post office, etc., district as Boro Kachari, signed by the Vice President of all Assam's tribal Sangha and so on. Records obtained during the course of inquiry revealed that the parents and grandparents of Sri Naba Kumar Sarania, late Lakhi Kanta Sarania, used surname titles such as Sakosh, Das, Deka, which was not listed under Boro Kachari. That's perfectly all right. We have no issue there at all. Srimati Dipantika Sarania, sister of Sri Naba Sarania, stated that she has an STP certificate and that she and her family belong to Sarania community, and her father used to write Das as his title surname. Well, with great respect, I see nothing there that can be seen as a reason for denying him the certificate. Sri Naba Kumar Sarania used the title Deka as recorded in the admission register, etc., for the year 1982. In the certificate of discharge or transfer to the reserve and recommendation for civil employment in 1980, issued by commanding officer of Assam Regiment Shillong, the class of late Lakhi Kanta Das, son of late Shela Ram Das, was written as Assamese and subclass as Das. Shri Raman Raba, a permanent government Gaumbura of 4 villages, etc., stated that Shri Naba Sarania was born in the village. His father's name was late Lakhanti Das, alias Sarakoch. The name of Naba Kumar Sarania, grandfather, was late so-and-so, etc., actually belongs to Kosh community, who became Sarania after taking religious sarana. So, my lords, contradictory findings. He belonged to Kosh community, but is not saying that he was not a tribal. Then there are the land records, registry records, where again the name is being seen as Das or Deka, etc. Then, my lords, finally, whereas the SLSC community, after careful perusal and examination of the written statements, documents, certificates, etc., submitted by Nava Kumar Sarania and Sri Sonso, and the report submitted by Vigilance Committee, is of the view that Sri Nava Kumar Sarania, son of late so-and-so, and of such and such address, does not belong to the Boro Kachari community. There is nowhere, my lords, with great respect, there is nowhere in the entire discussion that he is not a Boro Kachari or a Boro. Nowhere that discussion. And none of these people have been cross-examined. None of these people have been shown as to be critical to the opinion of the village. None of the senior village people have been examined. And it's a cursorily organized attempt to find ways and means of getting around the certificate that was granted. And my lords, the cancellation of the certificate, as your lordships have been informed in the affidavit that has just been filed, that cancellation has also not been given to me. Now, they're saying I haven't challenged it, but how would I challenge and they don't give me a cancellation certificate?
Okay.
Grateful for the patient hearing, my lord.
RTS department, my learned friend is feeling.
We are on a midst of a hearing.
Yes.
Can't you wait for some time?
41.
You go put somebody. We are in a midst. We'll have to
Yes.
call it midst of a hearing. Yes, Mr.
Well, just
Obliged.
a minute, two points that I just want to flag for your lordship. One is that page at the corrigendum that has been issued on the 1st of March 24. There's an important point here. Your lordship,
Where do you get it? Paste?
this is at page 201. My lord, this is in the counter affidavit, page 201.
Yes, 201.
201. Your lordship may just see two lines in this. At the top, my lord, this is 1st of March 2024. First is just a typo that they are changing, correcting 25/10/2019 instead of 25/10/2029. So that's not an issue that at all, my lord. Second paragraph. Also, please read as second report instead of first report as appears in line 1 of the 5th para of the speaking order. So, my lords, the confusion between first report and second report, this highlights that I have argued that there is only the first report. The second report cannot be an extension of first report. But there is this confusion of first and second report, but just be that as it may, like my lordship, just pointing out that the first and second report are important. My lords, the second point that is important, my lords, your lordship will find in the at page 98. My lord, this is in our reply. Our reply begins at page 87.
Page 90.
Page 98 onwards, my lords. It's just over the years, my lords, over the years, people who've been elected from the tribal communities, from the reserved category, your lordships will see at page 98. Page 98, it begins in 1952. If your lordships have that, page 98. Your lordships will see people who are variously elected, Vaikunnath Das, then Pakhiral Das, Surendranath Das, elected 2-3 times. Then there is Jagat Chandra Padgiri. Then again, Vaikunnath Das is elected. Manik Chandra Das is elected. Then, lords, if your lordship will go to the next page. Then in 1983, it's Jagat Padgiri. Then thereafter is Rekha Randas Boro and Rekha Randas Boro. And then, my lords, just below that a little bit, your lordships will see Purna Chandra Bora, Dilip Kumar Saikia, Pradhan Barua, Dilip Kumar Saikia, and Pradhan Barua. Well, these are various people who've been elected, interchangeable names, as I said. These are names or titles, as you might call them, that are used variously by people who are tribals. And therefore, the uncontested names given to the parents or parents using those names at the time of registration of land documents, etc., they would have been given by whoever was the writer of those documents. Well, it was just these 2 points I wanted your lordship to keep in mind. Grateful, my lords, grateful.
Yes, Mr.
At the very beginning, lordship, I would like to
just a minute. I just put his notes separately. I have prepared. Yes.
lordship is taking this matter for final disposal.
That way, if it is for final disposal, I will place everything which is relevant.
No, basically, Mr. Kushit,
My lords,
see, in terms of Madhuri Patil, it is the only remedy, kind of a part.
please.
So we would like to go deeper if we go for a final disposal.
Please, my lord.
Therefore, we are thinking of having a satisfaction whether this is a case for an interim order or that much.
Please, my lords. I understand. I understand. my lord.
That much only.
That means it is for interim.
For interim.
In-
Whether it's a case for an case of
Yeah.
after inquiry committee,
Yes.
case for any interim.
Yes. So their basic prayer lordship will find at page 39.
Page 39. Page
39 of the writ petition. They have challenged, their first challenge is against the vigilance cell constituted by the order dated 6/6/2019.
Okay.
So they are agreed by the vigilance cell constitution.
that is 6th of June 2019.
19.
Page 55.
Page 30.
Page 55 and I think
Page 6.
Annexer 7
is
is
page 55.
Yeah.
The constitution of the vigilance cell consisting of the director WPT and PC, deputy director WPT and PC, deputy superintendent of police CID, and police inspector 2 numbers. So basically, this
so
is
this is a constitution in terms of Madhuri Patil, not for this case. It is an
general one.
general.
General, but they have challenged. That's why
Okay.
I have to address this
Okay,
honorable court on the prayer.
Okay. Okay.
So this is the first.
Hmm.
Then was the order dated 11/7/2019 requesting for inquiry into the social status of the petitioner having no authority.
Okay.
So that is Annexer 9.
Page 58.
Page 58. The deputy director wrote to the director enclosing here with a petition received from Jonoklal Bostumatari. I am directed to request you to kindly inquire the caste status of Nobo Kumar Koronia, Honorable MP Kokrajhar,
Okay.
to the Vigilance Committee and submit the inquiry report to the state level scrutiny committee for caste verification. So this is the second prayer. Third prayer is the impugned speaking order of 12/1/2024, which I will place little bit later, Annexer 24/7. These are the main prayers. And in the interim, they have prayed, saying of the operation of 12/1/2024 and any consequential order.
Annexer 26 is the report. Oh no.
Page number dot page.
Page 110, I think. Saranya?
Yes, that is a speaking order, the impugned order, 111. 111, the Nelson's
27
number.
is 111 speaking order. What is Annexer 26?
The reconstitution of the committee, because there is an amalgamation of 2 directorates.
Okay.
Therefore, instead of 6 members, it has come down to 5 members, and which is also permissible under the
Yes.
subsequent Supreme Court order also. So,
Therefore, I've said these are the issues may not be so
because they have
intricate
already
to the,
submitted.
intricate to the actual
Exactly.
issue.
The main issue, now today, the main issue is, Lordship, the order of 12 January 2024.
12/1/2024.
And subsequently on 28th of January, the cancellation order.
That they have no specifically
There is no
challenged,
prayer.
no prayer, but they say that consequence. Look at that another aspect.
That is for interim, not for main prayer.
Non-main prayer.
Main prayer, they are not offended with the,
Okay.
because that's why I was expecting that there will be a response from the other side that they would like to file a fresh petition or amend this petition. But they are not doing it. Therefore, Lordship will consider this as that they are not agreed by the order of the cancellation. Now, I will come little bit later. How we proceeded.
Their basic attack is on the procedural aspect.
Absolutely.
Of course, because the factual findings
Exactly.
in a In a given
Because
case,
my also whole thrust is on paragraph 13, subpara 5.
Ah.
Whether it is a first report, second report, continued report, composite report, if everything is considered in the first report, the second report would not have been required. But the second report was required only because certain vital aspects were not looked into in terms of paragraph 13, subpara 5. In that respect, the same inquiry officer conducted further inquiry because the vigilance committee, they were not satisfied with the report submitted by him. In fact, the first report also goes against them. The first report, in my humble submission, is also goes against them. Only the opinion given by that gentleman who was the inspector of CID, he gave a different opinion. There's a conflict in the opinion itself. So I'll place everything. But before, what is the notification we have issued for the purpose of conducting this kind of inquiry? In terms of Madhuri Patil's case, in our affidavit, we have an act 18. 148. Lord people kindly take my affidavit, where Lord people find, because they are more concerned about the procedure, but I have to place before this honorable court what the procedure is all laid about in the notification dated 11th of May 2018, 148.
yes.
May I read this because this is very relevant. Issued by the Welfare of Plain Tribes and Backward Classes Department of Government of Assam, 11th May 2018. In pursuance of the directive of Honorable Supreme Court case Madhuri Patil versus Additional Commissioner, the state government has decided to create a vigilance cell at the directorate level and issue modalities for its functioning. Accordingly, the following instructions are issued for further simplification of the procedures of dealing with the matters relating to fake caste certificates. Vigilance cells are to be constituted in each directorate. At that point, there were two directorates. Directorate of Welfare of Plain Tribes and Backward Classes and Director of Welfare of Scheduled Caste, consisting of Deputy Superintendent of Police, CID Assam. The Supreme Court says Senior Deputy Superintendent of Police. In Assam, we do not have Senior Deputy DSP in our cadres. So we have taken Deputy Superintendent. So the Supreme Court's order says Senior, but we have Deputy Superintendent of Police. With such number of police inspectors as required to investigate into the social status claim of scheduled caste and scheduled tribe candidates. Superintendent of Police CID shall supervise the functioning of the vigilance cell. The vigilance cell shall function under the control of state level scrutiny committee. On receipt of the reference, the inspector who will be designated as the vigilance officer shall go to the local place of residence and original place from which the candidate hails and usually resides, or in case of migration to the town or city, the place from which he originally hailed from. The vigilance officer should personally verify and collect all the facts and social status claimed by the candidate or the parent or guardian as the case may be. He should also examine the school records, birth certificates, if any. He should also examine the parent, guardian, or the candidate in relation to their caste, etc., or such other person who have knowledge of the social status of the candidate and then submit a report to the concerned directorate together with all particulars as envisaged in the proforma, in particular, of the scheduled tribe relating to their peculiar anthropological, ethnological traits, deity, rituals, customs, mode of marriage, death ceremonies, method of burial of dead bodies, etc., by the caste or tribes or tribal communities concerned. The director concerned, on receipt of the report of the vigilance officer, if he found that the claim of social status is found to be not genuine or doubtful or spurious or falsely or wrongly claimed, the director concerned should issue show cause notice supplying a copy of the report of the vigilance officer to the candidate by registered post with acknowledgement due, or to the head of the educational institution concerned in which the candidate is studying or employed. The notice should indicate that the representation or reply, if any, would be made within 2 weeks from the date of receipt of the notice. In no case, only on receipt of request, more than 30 days shall be granted from the date of receipt of the notice. in case the candidate seeks an opportunity of hearing or request for an inquiry to be made in that behalf, the director on receipt of such representation reply shall convene the state level scrutiny committee and the secretary as chairman, who shall give reasonable opportunity to the candidate, parent, guardian to adduce all evidence in support of their claim. A public notice may be published in the village or locality, and if any person or association opposes such a claim, an opportunity to adduce evidence may be given to him. After giving such opportunity, either in person or through counsel, the committee may make such inquiry as it deems expedient and consider the claim vis-a-vis the objections raised by the candidate or opponent and pass the appropriate order with brief reasons in support thereof. In case the report is in favor of the candidate and found to be genuine and true, no further action need to be taken except where the report or the particulars given are procured or found to be false or fraudulently obtained, and in the latter event the same procedure as envisaged in para 2 and 3 be followed. Notice contemplated in para 2 and 3 should be issued to the parent guardian also in case the candidate is minor to appear before the committee with all evidence in his or their support of the claim for the social status certificate. The inquiry should be completed as expeditiously as possible, preferably by day-to-day proceedings within such period not exceeding 2 months. If after inquiry the state level scrutiny committee finds the claim to be false or spurious, they should pass an order cancelling the certificate. This is precisely what has been done. That committee. The committee finds the claim to be false and they should pass an order cancelling the certificate issued and confiscate the same. The certificate has to be confiscated. The state level scrutiny committee should communicate within 1 month from the date of conclusion of the proceedings the results of the inquiry to the parent, guardian, and the applicant. In case of any delay in finalizing the proceedings, and in the meantime the last date for admission into an educational institution or appointment to an officer post is getting expired, the candidate shall be admitted by the principal or such other authority competent in that behalf, or appointed on the basis of social status certificate already issued, or an affidavit duly sworn by the parents, guardian candidates before the competent officer or non-official. Such admission or appointment should be only provisional, subject to result of the inquiry by the scrutiny committee. In case the certificate obtained or social status claim is found to be false, the parent, guardian candidate should be prosecuted for making false claim. If the prosecution ends in a conviction, the accused is sentenced. It could be regarded as an offense involving moral turpitude, disqualification of elective post. Here it comes, Lordship, or offices under the state or the union, or election to any local body, legislature, or parliament. As soon as the finding is recorded by the state level scrutiny committee, holding that the certificate obtained was false, it should be simultaneously cancelled. So at the same time, and confiscated, and the same shall be communicated to the educational institution concerned or appointing authority by registered post with acknowledgement due, with a request to cancel the admission or the appointment. The principal, etc. of the educational institution responsible for making the admission or the appointing authority shall cancel the admission appointment without any further notice to the candidate and debar the candidate from further study or continue in office in a post. The last part is applicable here. The order passed by the committee shall be final and conclusive only subject to the proceedings under Article 226 of the Constitution. So this is a writ proceeding under
this
this.
was also given in Madhuri Patil.
Yes, these are basically we have just replicated.
Subsequently, some other judgment, it was modified, even read appeal will be made.
Readable, that is of 2012.
Some judgment.
Yes, 2012, 1 SCC is 53. So this is not a statutory appeal. In statutory appeal,
No,
appeal
it's
is
not.
admitted,
No,
the
that is not.
stay automatically comes. Here, it is not that case.
No.
That is why I am taking your lordship to
So
serial.
why I have said that, because since this is the remedy given,
Yes.
so for final determination, it requires a proper hearing. And therefore, I say, therefore, let us consider whether this
A
is
prima facie case
prima
is in
facie
your
case,
favor or
balance
not.
of convenience is there or not.
Yes.
That's all.
Now, in paragraph 2 of this office memorandum of 11th May, the details are given.
paragraph 2, 3, 4, 5
The
different state.
two is basically, it's a replicate of paragraph 13.5. What are the parameters the inquiry officer must look into? What should be the mode of his inquiry? What are the areas he have to go into? All these things are replicated here. Paragraph 2. So when the complaint came to us from one Jonaklal Bosumatari, so the authority, the vigilance cell, had a
When
meeting.
was the first complaint filed by this?
complaint.
His
Yes.
representative, Mr. Das? Yes, sir.
Complaint is at page 50 of the writ petition.
2019.
Yes.
11/6.
Yes, 11/6/2019. And it has been addressed to the chairman of state level scrutiny committee. The complaint was lodged by one Jonaklal Bosumatari. And one of their argument was, before proceeding any further, one of the argument was that this is a issue already settled in the earlier round of litigation. Therefore, I would like to place the judgment of the Supreme Court, and Supreme Court matter was also referred to in the submission of my learned senior friend for the petitioner.
That election petition.
Yes, Lordship. Page 117. That issue is still alive. That is what I am trying to emphasize now from the Supreme Court judgment, which Lordship will find at page 117. The judgment was delivered sometime on 31st October 2018, and the complaint came in 2019. Have Lordship got it?
No, here at paragraph 7, Supreme Court says
Yes.
this is not a subject matter.
It is not. That
Neither
is
is
why.
there any pleading nor
Exactly.
issue of frame with regard to the
Yes.
comprehensive authority.
Yes.
So
Yes.
this will have a separate.
That is why I am about to show Lordship this paragraph 7 only.
Ah.
7 says there is no challenge, and that issue was never heard. It was never framed.
They
Also.
said that in election petition, once the certificate here, that is not the subject matter.
That is not the subject
You
matter.
go.
Appropriate. And therefore, Jonaklal, subsequent to this judgment of 31st October 2018, in the year 2019, lodged the complaint before the state level scrutiny committee.
Okay.
So the issue was not decided earlier. I do not know what was the fate of the election petition, but we are not concerned about that.
Election petition was dismissed, then it went up to Supreme Court, and it says that this
Certificate was given, so it is a valid certificate for that purpose. But when the certificate itself is challenged, now we have to look into the core of the issue. So after this, the Vigilance Committee completed their formalities and entrusted the gentleman, Lordship, who was the Vigilance Officer.
Where is that?
Committee minute. Reference July 2000. I'll just July 2019. He was entrusted. Along with
30th July, I think.
30th July.
51, na?
Page 59.
Yes, 59.
Yes.
Okay.
Page 59 and
Serial 2, page 60.
Yes.
Serial 2 is we are concerned, not
Yes.
others.
So once the complaint came, then the Vigilance Committee had a meeting, and thereafter this director issued a letter to Jotu Malakar for the investigation. So the Vigilance Officer did the preliminary inquiry and submitted the report at page 63. So here, 23rd October 2019, Lordship may kindly note this date. 23rd October
2019.
2019. Furnishing of inquiry pen and reference was CID cell, Vigilance cell, that 24/6/2019. So there was a reference to the Vigilance Committee's meeting that constituted of 6 officers. Serial number 2. For verification of caste certificate of Nobo Kumar Horonia, MP Kokrajhar, Loktikanta so-and-so, I visited the given address, examined the person noted and other prominent persons of that locality and found that the said person belongs to Soronia Kochari community. All along my senior counsel from the other side was saying he belongs to Boro Kochari community. So the gentleman who did and submitted the first report, he also says, I visited the given address, examined the person noted and other prominent persons of that locality and found that the said persons belong to Horonia Kochari community, not Boro Kochari community.
So according to you, his report that he is a Soronia Authority Committee which is under purview STP category, it itself is on the face of record, it is not
Not
acceptable
there.
because Soronia Kochari is not STP.
Not STP, the government from 2012 onward is trying to convince the central government to make them ST planes. That Lord people
But whatsoever, as on that Soronia Kochari is not STP,
Not
that is
included.
their case.
Yes.
They say we are Boro Kochari,
Boro
not
Kochari.
Soronia Kochari.
But if they are relying, they are harping on this report. The finding is that the said person belongs to Horonia Kochari community, and in the next penultimate paragraph, it is in course of inquiry, next page, Lordship. It is found that the complainant lost by the civilian, namely Fatima Khatun, Jonoklal Bostumani and Krishna Sarkar, is not genuine. The incumbents noted belongs to OBC, STP and OBC. Ajirul Haq belongs to OBC, Nobo Kumar Horonia belongs to STP community, and Jibon Chandranath belongs to OBC. The complaint submitted by the applicant below before the director is based on no truth. So now this Jotu Malakar, he himself, his finding is that he belongs to Horonia Kochari community, and he says that the certificate is genuine. At this stage, and Lordship will also see what are the things he have done. Lordship may kindly come to the previous page, page 63. Last line. In this regard, I collected the letter issued by the Government of Assam, Department of Welfare of Plain Tribes and Backward Classes, Dispur, referred to the letter dated 15th of June 2018, addressed to all Deputy Commissioners of Districts of Assam and all SDO civils of Assam, directing to issue STP certificate to Horonia Kochari as Kochari tribes in Assam. For ready reference, I am enclosing the photocopy of the caste certificate along with the government letter as ready reference, which is annexed Annexer B. This letter was issued by the State of Assam in 2018 to all Deputy Commissioners, directing them to issue STP certificate to Horonia Kochari community. That also is void ab initio, because the state government has no power. As an advocate general, I'm submitting before this, we have overshoot our jurisdiction. The central government, the provisions of the constitution are very clear, series of Supreme Court judgments.
Presidential order.
Presidential order. And therefore, when the government realized this mistake, they have withdrawn it. That is a part of the PL. One paragraph. A PL was also going on. So,
But is this document having relevance in this case? Because according to them, certificate was 2011.
but
Inquiry
yes.
was on
No,
2019.
there was a PL also.
Ah.
Kolbari Educated Unemployed Youth Society and another represents so and so. They have also challenged.
So otherwise, these documents, why he has referred no relevance for this determination?
That is why this Jodura Malakar gave a preliminary. Then there's a subsequent report, which Lordship will find 74. And he did not do the inquiry as per paragraph 2 of the office memorandum of 2018 and as per paragraph 13.5 of the Madhuri Patil's case. Now, Lordship will kindly come to page 74. So, he wrote to the SP of CID, the chairman of that vigilance committee, reference submission of the inquiry report. He has not mentioned whether it is first inquiry or second inquiry. The first page 63, he also said furnishing of inquiry report. Here also furnishing of inquiry report. And in the first line, he says, in inviting a reference to the subject cited above and in continuation of the previous report, submitted on the matter, I have the honor to submit a report on the complaint submitted by Jonoklal Bosumatari of so-and-so against Nobokumar Foronia, which was enclosed to me for enquiry, endorsed to me for enquiry. As directed, the inquiry is conducted taking into consideration the below mentioned points, along with 11th May, along with those mentioned in the office memorandum dated 11th May 2018 of the WPT and BC department. So, my humble submission is that his first inquiry was basically on the certificate as well as the communication given by the state of Assam to the various deputy commissioners. Now he actually entered into the investigation. What is those areas? Ancestral caste certificate, legacy data verification, land document admission report in educational institution. And these are as a part of the office memorandum of 2018. Steps taken during inquiry. The complainant Jonoklal Bosumatari of village so-and-so was examined at CID headquarters, in which he produced a written statement duly signed by him, which is enclosed as Annexure A. The complainant stated that the All Assam Tribal Sangha, being an NGO, is no competent authority to issue caste certificate, and that Nobokumar Foronia has obtained STP by claiming to be Boro Kosari, suppressing the fact that the community to which he belongs, that is Kochari Foronia, this is the finding of the inquiry officer also in the first report, is not notified in the constitutional order of 1950 as amended from time to time under Article 342. The complainant further stated that Foronia people adopted non-tribal Assamese caste Hindu surnames like Das, Deka, Hoikia, Foronia, etc., along with general caste Assamese language, culture, customs, tradition, festival, dress, religious belief, worship, that is Namghar, etc., which are distinctly different from Boro Kacharis, who have their own sets of tribal surnames and own language, culture, customs, tradition, festival, rituals, ceremonies, dress, food, religious belief, open worship place known as Garjasthali and Kailasthali, folk songs, folk dance, etc. The Boro Kacharis have their own closely knitted clan-based surnames peculiar to the community related to nature, such as Bosumatari art folk, Narjari jute folk, Doimari water folk, Ishlari god folk, etc. Thus, Nobokumar Foronia cannot claim that he belongs to Boro Kachari as his surname is Soronia, which is not a Boro Kachari surname, the complainant stated. The complainant produced the following documents. I am not taking this honorable court at this stage. Then findings, Lordship. He has given all this, but in our so-cause notice, we have capitalized everything. Findings at page 77. From the copy of the official letter forwarded to Secretary to the Government of Assam WPT dated 21st April 2014 by SDO Civil Tamulpur Division, it has been found that the concerned officer has stated, till receipt of direction from the authority in this regard, the process of countersigning of Soronia people shown as Rabha or Borga is kept in abeyance. Copy of affidavit submitted by Binita Pegu, Deputy Secretary of the Government of Assam, WPT and BC Department, to the Honorable High Court dated on 26/5/2015 has revealed that in point number 9 of the affidavit, the deponent clarified that by saying that the deponent begs to state that Foronia Kosari has not been enlisted in the ST list of Assam as per the Scheduled Caste and Scheduled Tribe order as amended from time to time. Over Srinivasan, Under Secretary Government of India, cautioned against issuing certificate without proper verification by letter dated 22nd March 1977. In its order dated WPC so-and-so 28/5/2014, the Honorable High Court had observed that Foronia is not enlisted tribe in the list of scheduled tribes incorporated in Central Order number 22, though tribe certificate has been issued to Nobokumar Foronia. Further, the Honorable Court also ordered that all Assam Tribal Sangha to also ordered the All Assam Tribal Sangha to issue tribal only to those persons falling in the categories listed in Central Order dated Order number 22. The STP certificate issued on 12/10/2011 by the Vice President, All Assam Tribal Sangha, Tamulpur District Unit, and countersigned by SDO Civil Tamulpur on 19/10/2011 shows that the certificate was issued in the name of Nobokumar Foronia, late son of so-and-so, as Boro Kosari, The certificate also says Boru Kosari. In his statement, the General Secretary of the All Assam Tribal Sangha Tamulpur Unit, Sri Pavitra Narjari, son of so-and-so, stated that there is record of STP certificate, which was issued to Nobokumar Koronia, signed by the then Vice President, late Kailas Rabha. In her statement, Srimati Deepika Das stated that it has been around 26 years since her husband, who was working in military, expired. She said that she has 3 children, 3 sons, 3 daughters, and all of them have caste certificate. So what caste certificate we do not know here at this stage, but for the other caste, Koronia or their original coach, their certificate should have been OBC, not STP. She further stated that she has no caste certificate of her own, as there was no requirement of caste certificate at that time. She also said that her husband had no siblings and he wrote Das as his surname. Srimati Dipannita Koronia, sister of Nobokumar Koronia, stated that she is working in a beauty parlor and stopped studying after passing PU from Tamulpur HS. She further stated she has STP certificate and she and her family belong to Koronia community, and father used to write Das as his title. Sri Ajit Boru, president of APSU Tamulpur unit, stated that Nobokumar Koronia's residence is located in Digholipar village and he originally belonged to Coast community. So APSU person said he is coach. He became Koronia after taking Koron. One cannot change caste lordship by this process. That is a settled position of law. His father, late Lokhikanto Das, and his mother also wrote Das as their title. He further stated that Koronias do not belong to STP. Scrutiny of admission register of Tamulpur Government MV School for the year 1982 has revealed that name of Sri Nobokumar Koronia was written as Nobokumar Deka, son of so-and-so, as serial number 59. In the certificate issued by Commanding Officer of Assam Regimental Center, Shillong, certificate of discharge or transfer to the reserve and recommendation of for civil employment dated 15 November 1980, the name of Nobokumar Koronia's father was written as Nayak Lokhikanto Das, son of so-and-so. His class was written as Assamese and subclass was written as Das. From the above fact, it can be found that Nobokumar Koronia and his family were using titles Das, Deka, which do not fall under the category of Boro Kosari. Very categorical finding, Lordship here. Sri Roman Rabha stated that he is a government Gaon-Bura. He is permanent Gaon-Bura of 4 villages, namely Ulubari village 2, Jamuhari and temporary Gaon-Bura of 6 villages, namely Tamulpur, Chirangbari, East Thauli, Timlapur, Digholipur is their village, and Modarbari. He stated that Nobo Koronia was born in Digholipar village. His father's name was late Lokhikanto Das, alias Korukuch. His father expired around 25-26 years back and he was working in Assam Regiment. His father expired during an accident while working in Assam Regiment. The name of Nobokumar Koronia's grandfather was late Selaram Das. He was originally from Digholipar, as both the grandfather and father were born there. Nobo Koronia's family actually belonged to Coast community, the Gaon-Bura says, who became Koronia after taking religious Koron. Even marriage does not allow a person to change his title, caste. The mother of Nobokumar Koronia is Deepika Bala Das, whose marriage was conducted based on mainstream rites, traditions, and not according to traditional rites, rituals of Boros and Ravas. These are necessities under the norms. The NRC legacy data record shows that the title of Nobokumar Koronia's father, late Lokhikanto, was Korukuch, which do not fall under Boru Kosari. In the land cheater register, the name of Nobokumar Koronia's father was written as Sri Lokhi Korukuch, son of Sela Korukuch.
Just for a clarification, this finding that Sorukos which do not fall under Boro Kosari from the material or anything notified that these are...
To get STP, we have particular names of the caste. So whether it is Korukuch or Koronia, nobody figures here under the central order of that number 20.
Presidential order.
Yes, presidential.
Is it in a part of...
It is part of in our affidavit. I'll come to that. And I will also come to the government's endeavor how to bring the Horonia into the fold of tribe. That effort, that records also will give.
I think not all Horonias, those Horonias, because Horonias are having different part. Some courses
I will
become
have a debate
Horonias,
with my friend after the case is
some
over.
Boros, those who are originally tribal. Isn't it? Now, this is not part of this debate, but
Horonia is not a separate identical caste. That I admit. That is too much.
this is not. Horonia is, it is Soron from different.
Yes.
It may be from Boro,
By stage
yes.
of
it may be
religion
from Coast.
The word Horon.
Horon.
Horon is taking the
Whether you are Horonia Boru or Horonia Coast. That is the issue.
Yes, Lordship,
Isn't
that's
it?
exactly the point.
Issue is whether you are Boru origin Horon or
Yes.
Coast origin
Or you are
Horon.
pretending to be a Boro. Or
That is the
pretending
issue. They are proposing.
that is the
They are
thing.
proposing to bring under STP Horonias. Those are originally tribals. That is Boros.
Boros.
Not all Soron.
No, in their case, it is coach
No.
who want to take Horon and become
Therefore,
possible.
their case is that we are Boro Kochari. We have Horonia by virtue of taking
Taking
Horon.
But it's not a separate tribe or
I am
identical.
taking Horon, but originally I am Boro Kochari, therefore caste certificate.
Exactly, Lord.
The report says that you are a Horonia, no dispute on that. But you are a Horonia from Coast, not from the Boro. Moment you are Horonia from Coast, you are not entitled for certificate. This is the
Horonia is
case.
the
This is the case.
transformation part. Transformation component.
This is the case.
Mile.
Now we'll have to see what is the findings and whether for the purpose of today's, what is the procedure followed. Now tell me, the procedure says if there is two parts, one as Mr. Khurshid has argued, that suppose you have a report.
Right.
Let us be clear on, for my understanding. When there is a report, right or wrong, suppose it is given a clean sheet or affirms that this is a certificate, is correct, or he is a tribal. Now, whether matter will end there, whether matter will end there, that is a debatable issue. But question is, they say that the report itself is a perverse report. So we proceeded. The question will come whether for further proceeding with an inquiry, when they are not satisfied, was a notice required to be issued, saying that, see, this is the report, we are not happy with this report, we are continuing with further examining. This is one issue. Second is, when your inquiry report was done, investigation was done, report was submitted, the procedure laid down under the communication pursuant to Madhuri Patil's decision, that give you different opportunity. Suppose a vigilance report is given, you are not happy. You can say, I am not happy, please have a further inquiry and give me a chance to lead evidence and cross-examine. Where is that? In your report, nothing is there.
Pass it in favor of me.
Just then they are bound to have a second inquiry. But you must demand. You have demanded only personal hearing. You will have to answer that.
My lord,
Not only personally, they requested for some documents, and documents were also submitted to him.
My lord,
if they wanted to adduce evidence, that opportunity they never demanded.
If the first report is to be rejected, my lord, they must draw an opinion that we are not, but Madhuri Patil 5 para is there.
No.
Furious, wrongfully taken, my lord, whatever it is.
Not only Madhuri Patil, I think that can be in the in their procedure itself.
That has been any material, my lord. What are same orders using in the other
Yes, proceed, Mr. Advocate.
Yes.
My lord.
Now, Lordship, the thing, what is the report? It is not a question of first report or second report. It is a composite report because on the basis of both the reports, the SOCOS was issued. Not on the basis of first report, a SOCO was issued, he replied, then we went for another report. No. Once the complete information came to the vigilance cell, they forwarded it to the state level scrutiny committee, screening committee. Then the SOCOS notice was issued on the basis of both the report. Today, yesterday we filed one affidavit. Today we seek the permission from this honorable court. We file an additional affidavit. Will Lordship consider only the first part or the second part?
I put that
Exactly.
whether this matter is end on the first report or if they are, suppose a clean sheet it is not disclosed to you. That is our
Yes, it was not
Mr.
disclosed. This is
Kushi, just-
internal.
Just understand their argument will be first report is not a report at all. Or we are having the power to continue with the investigation, and when we had the conclusive findings, then we follow the
Yes.
procedure. This is your argument.
Absolutely, Lordship. The first report was a part. Then we went ahead with the three very important components. What are those three components? Ancestors' caste status, which I am reading now. In the second report, all these details have come. Legacy data verification, the NRC and etc. Land documents, Mati Khajana will come there. And the admission report, what was there in his educational qualification and his school record. So these are part of which are necessitated in terms of paragraph 13.5, 35 to later. So these are the areas, these are the parameters, these are the criteria which the vigilance officer must look into. The first report is very narrow, mechanical, and that report also says he belongs to Soronia Kothari. First report's finding, I have found, he have used a specific language line at page 63. I visited the given address, examined the person noted and other prominent persons of that locality and found, this is the finding, and found that the said person belongs to Horonia Kosari community, not Boro Kosari community. What more is required? So that report is not helping them, even if you consider that is the final report. But this is not the final report. This is neither an interim report. It's a part of the report, and finally it culminated. If we take both, then on the basis of both the report, the so cause was issued. Therefore, the so cause will be very important now. Let me continue from this notice. What was the findings? Page 78. The government Gambura I have read out. On now NRC, paragraph 13. The NRC legacy data record shows that the title of Nobokumar Horonia's father, late Loktikanda Horonia, was Korukuch, which do not fall under Boro Kochari. In the land sita, the name of Nobokumar Horonia's father was written as Lokti Horukus, son of Sela Horukus, address Digholipar. In the land Jomabondi record, the name of Nobokumar Horonia's mother, which was written as Deepika Das, was struck off and Horukus was written just above the name. There's a correction also. Another title, Horu Das, was also given in bracket below the name Srimati Deepika Das. The name of Nobokumar Horonia's father was written as late Loktikanta, following by, there is something illegible, which may assume to be Horu Das. There is another entry in the name of Nobokumar Horonia's mother as Deepika Das Horonia, late wife of late Lokti. According to HS certificate, the father's name of Nobokumar Horonia was recorded Loktikanta Horonia. From the above given points, which were collected during the course of inquiry, it can be seen that the process of countersigning Horonia people shown as Rabha or Boru Kachari has been kept in abeyance by the concerned SDO Civil. And Srimati Binita Pegu, Deputy Secretary to the Government of Assam, WPT and BC Department, in her affidavit submitted to the Honorable Guwahati High Court on 26 May 2015, had stated that Horonia Kosari had not been enlisted in the ST list of Assam as per the Scheduled Caste and Scheduled Tribe order as amended from time to time. Moreover, over Srinivasan's Undersecretary's letter dated 22nd March 1977 had cautioned against issuing certificates without proper verification. Observing that Horonia is not enlisted in the tribe in the list of scheduled tribes incorporated in Central Order Number 2, though tribe certificate had been issued to Nobokumar Horonia, the Honorable High Court in WPC 2580-2014 dated so and so ordered of all Assam tribal Sangha to issue tribe certificates only to those falling in the category listed in Central Order 22. Further, Deepika Das, son of wife of late Loktikanta Horonia, stated that her husband had no siblings and wrote Das in her title surname. Srimati Dipannita Horonia, sister of Nobokumar Horonia, also stated that her father used to write Das as his title. This was further confirmed by Ujit Boro, president of APSU Tamulpur unit, who stated that Nobokumar Horonia's residence is located at Digholipar and he originally belonged to Coast community. He became Horonia after taking Horon. His father, late Loktikanto Das, and his mother also wrote Das as their title. Government Gambura, Roman Rabha further stated that Nobokhoronia was born in Digholipar village. His father was late Lokhikanto, alias Porukus. His father expired 26 years back and was working in Assam regiment. These are repetitions, Lordship. Coming to the next paragraph. Taking into consideration the practice of Boru Kochari to use surnames peculiar to this, also I have already read out. Scrutiny of admission register of Tamulpur Government School of the year, Nobokumar Khoronia was written as Nobokumar Deka. Then last paragraph, that land records details. And thereafter at page 81, though the STP certificate was issued in the name of Nobokumar Khoronia of so-and-so as Boru Kochari on 12/10/2011 by the Vice President All Assam Tribal Sangha Tamulpur District Unit and countersigned by SDO Civil Tamulpur on 19/10/2011. Record obtained during the course of inquiry revealed that the parent and grandparent of Nobokumar Khoronia, son of late Lokhikanto Khoronia, used titles such as Poruku Das Deka, which are not listed under Boru Kochari. Further, Nobokumar Khoronia used the title Deka as recorded in the admission register of Tamulpur Government MV School for the year 1982. In fact, certificate of discharge of transfer to the reserve and recommendation for civil employment dated 15 November 1980 issued by the commanding officer of Assam Regiment Center Shillong. The class of Lokhiga so-and-so was written as Assamese and subclasses Das, which shows that the parent of Nobokumar Khoronia were not Boru Kochari. Moreover, interchange of titles, surnames, etc. Das, Porukus, Deka, Khoronia by Nobokumar Khoronian family is another cause of concern, submitted for favorable perusal and necessary action. So this is the report submitted. So on the basis of that, Lordship, the SOCOS was issued. The second report came on 4th of Lordship. Will kindly note the previous page, the date, 4/2/2020. And page 63, the first report,
2310.
23/10/2019, and subsequent report is, the full report was at 4/2/2020. And when was the SOCOS issued? Thereafter, 11th of March 2020. We have to take the matter in chronological order. SOCOS notice on doubtful STP. So this was issued. So basically, whatever I have stated just now, Lordship, from those records, these are quoted here. Last paragraph of the first page, page 82. Whereas the Vigilance Officer Inspector Jodu Ram Malakar duly conducted the inquiry. Here, there is no mention of first inquiry, second inquiry, and submitted his report on 4/2/2020, wherein the following points were highlighted. These are the points which I have just stated. I'll not take your Lordship and
Go to
repeat it.
page 84.
84. Now, whereas a discussion on the above points shows that there are many questions of genuineness and doubt about your claim to belong to Boru Kochari community. The Assam Regiment Center records your father's caste as Assamese. Notably, your parents used the title Das before shifting to Shoronia. It is also known that any person from any community, tribal or non-tribal, when he or she takes up Soron religion, becomes Khoronia. NRC legacy data, land record, and your school records of 1982 also prove that your parents were either Das, Deka, or Porukus. Statement of Gaumbra of your village and others also state that your parents belong to Kush community. It is also reported that the marriage ceremony of your parents and was conducted based on mainstream rites and not according to the traditional rites, rituals, and of Boros and Rabhas. No evidence is found to support your credentials as member of ST community Boru Kochari. Whereas prima facie it is found that the report of the vigilance officer that the STP certificate issued in your favor is doubtful from different angles as enumerated in the inquiry report, copy and close. So we have given him the report. Whereas in view of the findings of the vigilance officer, your STP certificate is liable to be immediately cancelled and confiscation. You are therefore issued this notice to submit your explanation as to why government in the WPT and BC department should not cancel your STP certificate forthwith. Your replies should reach this office within 2 weeks from the receipt of this letter. Failure to reply within the stipulated time shall render any appeal letter null and void. should you require more time for submission of explanation or desire an opportunity of hearing, your petition for the same has to be reached the undersigned within 2 weeks from the receipt of this letter. However, please note that the maximum time extension shall be given is 30 days. Then there was a request that because of COVID, he wanted some extra time. So ultimately, he submitted his reply. One letter of extension of time is at page 85. Lordship will kindly see page 86. He requested for some documents. Although it was submitted that through RTI he obtained. But we have given, Lordship will kindly see page 86 last line.
You have
Copies
given
of,
APCQ something like
yes,
that.
are enclosed herewith. So
Then
whatever
he-
he requested,
he
we
have
wanted a fair hearing, Lordship. We have nothing to
And
do.
in the reply, he said this is not legible. That
Yes.
we have.
Yes, Lordship has only gone through it. So the reply, he came on 31st of August, page 87. So as it is not final hearing, I'm not going into details. So he was given full opportunity. So he was given additional documents, time, hearing, all opportunities was given to him. Page 91, one line I would like to place.
Page 91.
91 of his part of his reply.
Okay.
Now I am replying the highlighted points of the so cause notice. So in the second paragraph.
Just a minute. Page
91. With regard to the statements of allegations made in highlighted point number 2 of the so cause notice, I state that the order dated 28/5/2014 passed in WPC number 2580/2014 by the Honorable Court observing that Soronia is not enlisted scheduled tribe is the correct position of law. This is his own submission. So what more is actually required? He himself has said. Then in the next page, he mentioned about some political rivalry. We are not on that, Lordship. In fact, there is a delay of 4 years in coming to the conclusion. In fact, this is to his beneficial. If the government has delayed by 4 years, he has enjoyed his membership in the parliament for 4 long years. Otherwise, automatically, when the order is passed, Lordship, the certificate has to be cancelled and it has to be confiscated. And in case of schools and the offices, the office heads should be informed, and there should be no opportunity of any following of natural justice thereafter. No notice is required. So same could have been done by the state of Assam by giving the notice to the speaker, Lordship, or the vice president. So this is a blessing in disguise for him, that delay of 4 years. No.
So now this
The reply, he has done all these things. So as it is not final hearing, I am not going to take your Lordship to all this. Ultimately, his submission at one with my learned senior friend from the other side said that in some other constituencies, Das, Deka, etc. belongs to ST. So
that is a
different
on,
issue.
On merit, that is
That is on each, if there is a complaint, then another round of inquiry will go forward. That is an additional reply. So he gave 2 replies. One first reply, then the second reply. If he are aggrieved by our 2 reports, then we should also discard his second report if the same principle is to be followed. It is not like that. In fair hearing, everybody should be given fair opportunity so that all their stands can be made forth before the inquiry committee.
Okay.
So when the report came, Lordship, then the Vigilance Committee had a meeting and they have forwarded it to the state level inquiry committee, page 102. All the procedures were followed. The Vigilance Committee's minutes at page 102. Mrigesh Borua, ACS Director, WPTBC, Jadov Pegu, Director, Deputy Director, then Mr. Sanchan, APS DSP CID, Jugen Borman, Inspector CID, and Rajiv Borua. After thorough discussion among the members, the following resolutions were adopted. The case relating to Nobo Kumar Phoronia would be referred to the state level scrutiny committee for adjudication and personal hearing as requested by the defendant Sri Nobo Kumar Phoronia. A letter shall be sent to the chairperson state level scrutiny committee enclosing copies of all documents relating to the case for convening a meeting of the SLC for adjudicating the case. So due procedure was followed. It is not that out of blue all this inquiry has started.
11/3/2020 was issued by whom? Page 82, Annexure 18.
82.
The notice.
The director.
So cause notice.
So cause was issued by the director. It has to be issued by the director.
Director.
Yes.
On the basis of the vigilance report.
Exactly.
Vigilance
Yes.
report.
Yes, Lord.
On the basis of vigilance committee's report. Then the determination is to be referred to the state level.
Yes. Suppose the report has come in favor of him, then sending it to the state level scrutiny committee is not necessary. Paragraph 6 or 7 of the Madhuri Patil state. But here the final report says the overall report, and the show cause notice was based on both the report, and therefore in the now show cause reply he has given.
Final order is by the
state level. Yes, that
Scrutiny
lordship will find one
Because
one
authority
one.
to determination to make a determination is the state committee, not the vigilance.
No.
Vigilance committee is having the power to investigate.
They do the inquiry. It's like the police IO. IO and the district authorities submit the search sheet. If it is a final report, no further action is required. If it is a charge sheet, the trial starts. The trial is conducted by the state level scrutiny committee, just like the criminal proceedings. Lordship. 111 Lordship will kindly come for a moment. So it is at page 12 January 2024. Regarding narration of the preliminary facts, then page 112. Lordship will kindly come to the third paragraph. Sorry, second paragraph. Whereas Novo Phoronia by petition dated 8/4/2020 and 18/6/2020 sought extension of time to submit his replies and later he submitted his reply on 31st August 2020 to his focus notice to the director of WPT and BC department. Whereas Jonaklal Bosumatari submitted he is the complainant. His replies to the focus notice issued to the by the director on 21/9/2020. Whereas CID in the meantime submitted their second report by letter dated 4/3/2020. These are the dates were later on corrected, Lordship, some date. Whereas on receipt of the second report from CID Vigilance Committee meeting held on 14/9/2010 and decided to refer the case to state level scrutiny committee dated 18/9/2020, which I have just placed, Lordship. Whereas the hearing of the state level scrutiny committee was held on 11/11/2020, the committee heard Nobo Kumar Phoronia in person and perused his stand as replied dated 31/8/2020 to his so-cause notice submitted to the director of WPT and BC department. So he was given full opportunity. Not a single, his reply says that I took some more time to give the reply because certain documents were not legible. So those documents were subsequently supplied. And after getting the complete sets of documents, he submitted his reply on 31st of August 2020. And he was given the opportunity of a personal hearing. Where is the request from his side to adduce defense, adduce evidence, number one? Where is the request from his side to have the opportunity of cross-examination? If he had sought that also, Lordship, we would have given. So first, there should be a demand. We will not invite people to cross-examine any person. So whatever was requested from his side, Lordship, the incumbent side, Lordship, everything was fulfilled. Even the complainant was also heard in person. Next paragraph. Whereas hearing of the state level committee was held on 4/12/20, wherein the committee heard Sri Jonaklal Bosumatari in person. So both the petitioners and the respondents were heard. Next page, Lordship. Whereas the committee referred to the comprehensive procedure for issuance of social status certificate and the procedure for scrutinizing the genuinity or falsity of social status certificate has been laid down by the Honorable Court in the case of Madhuri Patil, wherein it has been stated that this is the requirement, Lordship. Paragraph 13(5). It's quoted. Next paragraph. Whereas SLLC examined in detail the findings of the Vigilance Committee, so Vigilance Committee's findings were also noted here. Thereafter, at page 115, whereas the SLSC committee, after careful perusal and examination of the written statement, documents, certificates, etc., submitted by Nobo Kumar Horania and Jonaklal Bosumatari, and the report submitted by the Vigilance Committee, is of the view that Nobo Kumar Horania, son of so-and-so, alias so-and-so, alias so-and-so, of village so-and-so, does not belong to Boru /Boru Kochari community. This is the finding.
Just one minute. It's fine. Report is that report is given. Sons of hearing was given to both the parties. Is it a not a minimum requirement that at least what is their understanding or why they have rejected the other side content? It is a valuable right.
Now,
is it not necessary?
Yes. Now here,
see the it's a high level committee. It is having almost the last part for determination of our person's right, wrongly given, rightly given. We are not present. It is a stage where the next stage is only writ court, and writ court's judicial power of judicial review is very limited in case of fact finding things.
No, facts are before this honorable court.
No, that we understand, but we cannot go to the disputed facts and determine. This is the last committee to decide. Is not a minimum necessity that he has argued, because they have more or less so and so said so and so we accept it. What is the context? Is it just
this is the problem in all administrative committees. This is the problem. Lordship will have to distinguish between the judicial committees, the role played by this honorable court, or the other members of the
ultimately they are giving
that reasoning is not there, but that does not make the order. It is not vitiated. There are a series of judgments also. If a judgment of this honorable, if there is no reason, then Lordship, the person will get to give a good appeal to that case on those grounds. But here, that opportunity is not there. And they, in most of the orders, the speaking orders, Lordship will find that day to day, because they are not judicially trained. That is the lacuna they have, the administrative power.
Concept of Madhuri Patil was to settle all these disputes to this committee. So it's because it's a determination of right.
Yes, now
the object before paragraph 13 was specific, that no person should have a benefit depriving the actual scheduled tribes or scheduled tribe people. Is it not?
Absolutely.
This was the object for why at paragraph 13 that criteria was given. And on the basis of it, in fact, the state has given a procedure which is having the...
That is why we are fighting that case of Tooth and Leather Monsoon. That is why we are fighting. A person who does not deserve that, even there is an honorable court order, still we are not complying.
So, basically, therefore,
a person genuinely
you have also laid down some procedures which is which supports the right of a person. Natural justice is provided.
Now, Lordship, forget about all this procedure. Let him convince this honorable court that he belongs to Boru Kochari. We are giving that leeway on.
Anyway, this was just while reading.
Yes, Lordship has very pertinently.
While reading this, everything is fine.
End of the day, if the opportunity is given to him also, on behalf of the state, I am saying, Lordship.
But no, I understand. But the principle of law is equally well settled that every state action must be supported by reason. Reason should be disclosed because it is a facet of Article 14.
Absolutely. But if we look at, because there are series of findings that he does not belong to Boru Kochari. Series of findings. So the final operative part is very effective.
No, this operative part, if we go by this, that means that, okay, we accept the vigilance committee's report. It is fine. This or whatever.
Now,
inquiry has
what
been-
he has said,
Hmm.
after careful perusal of examination of the written statement,
Hmm.
documents, certificates submitted by Nobo Kumar Koronia, Jonoklal, and the report submitted by Vile, is of the view. So after considering all these things, they could have added 2 more lines.
Anyway. Yes.
This I also found that the reasoning is not there, proper reasoning. They have that we have relied. So now if what they have relied, I have to take this honorable court to all those paragraphs once more.
Not necessarily
Yes,
to have
but-
read only. They have
So-
put it all this. In fact, I have
So-
marked the basic reason is,
Yes.
if we can mark that, father is Sorukos, Das, Deka, which are not listed as Borokosari.
Yes, yes.
Number 1. Then is Soronia community, that sister is not, is belongs to Soronia community. Nobokumar Soronia used the title Deka. His father's
He also
certificate,
used other
other anyway. So his father's that released
Borput, Das.
from the thing says Assamese, and
Das.
some people of Digolipa says he's Coast community, and NRC legality data says he's Soru Coast.
Soru
So therefore, on that basis, committee concluded that he is not a person from Boru Kasari community.
Absolutely. Okay. He has all the other credentials
Yes.
except this credential. So now that notification, central government's notification, page number 202. The Constitution Schedule Tribes Order 1950, CO number 2022, 22 only. So far as Assam is concerned, Lordship will find that it is at page 204. Have Lordship got it?
Hmm.
In the state of Assam, including the borderland territorial area district, excluding the autonomous district of Karbi Anglong and North Kachar, Bormon Sin Kachar, Boro, Boro Kochari, Deuri, Hujai, Kochari Sunwat. These are the so nowhere there Lordship will find Koronia or Koch or Horukuch.
So therefore, according to you, he is
Yes.
a Forukos and his
Yes.
certificate was Borokosari.
Yes. Now Lordship will kindly come to another reference, page 217. Page 218. Sorry, 217.
Yeah.
Standing Committee on Social Justice and Empowerment 2011-12, 15 Lok Sabha, Ministry of Tribal, the Constitution Scheduled Tribes Order, Second Amendment Bill 2011.
Hmm.
They have prepared this amendment bill in 2011. And what is the status there? Lordship will kindly come to
Page
page 220,
235.
233.
230.
Assam, serial number 8. Koronia
Yes,
Kosari referred to state government for further justification on the comments of RGI on 5/5/2006. So that is the status till now. So the state government wants Koronia Kosari to be included in the list of tribal, but it has not been approved. Just like another 5 identically.
Yes, Mr. Sarania, your case is that though my title is Sarania Das Deka Sorukos, but I am a person of Borokosari, not a Horonia
That's my
Kosari.
claim.
That is you. And therefore a certificate was issued. Certificate was not held to be fraudulent. It was issued by a competent authority. Therefore that remains. And in without any allegations of fraud and etc. This this
Second inquiry cannot go.
Oh, yeah. That is
And
you.
that inquiry is coming from 2 different sources, man. The first inquiry from different letter, second inquiry is from different letter. First inquiry include 3%, second inquiry will include also different 3%. Report is only in case of
But on the basis of the complaint of Jonakla.
my lord. And that also not provided to us.
Yeah.
Later we got.
Baloj, may I,
No, I
No,
have,
look, he'll
if
not
my
complete.
learned senior wants to
sorry.
say something, I have no objection. I'll take some more
No,
time.
no, no, I'd rather you complete, then I'll
So let
just,
him complete so that you let.
So when the first report was given,
Hmm.
the opinion preliminary opinion expressed by the officer, vigilance officer, is purely based on the state government's circulation of letter of 2018, whereby the deputy commissioners of all districts were asked to issue caste certificate to Koronia Kosari. That lordship will see page 63 once more, because this is more relevant.
Because it issue us a certificate is already there, which is Boro Kosari.
Boro Kosari.
Boro Kosari. Now, he says that it is Soroni Kosari. Your
Soroniya.
case is that when you yourself has concluded Soroniya Kosari, which is not notified under presidential order, therefore you are finding that his STP is not is absolutely purpose. Therefore, we continue with the inquiry.
Absolutely, and his own admission. And his own admission, he says that that is the correct position of law in his reply.
No, his position is that yes, it is a correct position. Soroniya Kosaris are not
included.
Not included. Soroniya Kosaris are not included. That is an admitted position.
And what the
report
officer
favoring him certified him to be a Soroniya Kosari.
That is why my.
So according to you, in both the inquiry report, it is fortified that he is a man of Soroniya.
Soroniya Kosari.
So when Soroniya Kosari, it is admitted it is not a
right.
Right. Had it been a Boro Kosari,
that yes.
That
so his own the finding of
because
the
Koronias from Bodo are recognized in STP, and Koronias from other castes are not recognized in STP.
No, Koronia Boro till now that is also not there.
No, Bodo Kosari.
Boro Kosari. Boro Kosari, not Koronia.
No, Boro is a different caste.
And Boro
Kosari is something.
Yes.
Kosaris are different Kosari.
Boro
Soroniya Kosaris, Boro Kosaris. So Soronias are not in.
So Boro Kosari and Boro are.
Otherwise, the word Boro Kosari would not have been there. Bodo would have completed. Okay, Bodo means Bodo, whether he's Koronia or non-Horian issue.
Lord.
But those Bodo, but they took Soron are also included.
Koron lordship, then again that is a debatable thing. Whether by Koron one can change his caste or not.
No. If we say that this is because it cannot change. This is your argument. It cannot be changed.
It cannot be.
So therefore, Bodos who are originally Boro, therefore, even if they are Soronias, they are given.
Doesn't make any change.
Make any sense. Therefore, Bodo Kosaris are given.
Even by marriage, if a lady married a civil tribe, and she cannot contest in a seat reserved for the tribal. By marriage also.
This proposal for this is not part of this context. This Soronia, that proposal is given. Because maybe some people
there is a demand from that
demand, because their demand is that though we are Soronias, originally we are civil tribe. That is why.
But till now,
that is what is your argument. That even if you change, that is maybe government's policy. Then even if you can become Soronias, but you are originally tribal, so we will recognize. That may be the principle.
But till now, it is still going on. It is still in the.
Let us not comment on this.
Yes, at least not by this honorable court.
On this basis.
We can say a lot of things.
Yes.
We are not under oath.
These are ideas.
So now, thereafter the story progressed further. The Lordship will kindly take my additional affidavit.
Yes. File today?
Yes.
Yes.
Here, paragraph 2. The deponent begs to state that the consequent upon the passing of the speaking order on 12/1/2024 passed by the state level scrutiny committee, declaring the writ petitioner to be not a person belonging to STP of Assam, the SLSC on 21/2024 had cancelled the STP issued to the petitioner Nobokumar Koronia, issued by all Assam Tribal Sangha Tamulpur unit, countersigned by SDO Civil Tamulpur by number so-and-so 17/10/2011. It is pertinent to mention that the cancellation order dated 21/2024 passed by SLSC, cancelling the STP certificate of the petitioner, is not under challenge in this petition. Even if Lordship says the opinion, this order is yet to be challenged, and this order was furnished to them on 13th of February. Within 1 month, we have to furnish it. Lordship will kindly see this email. Tribal Affairs, Assam, with the email address at top. It is written to the CID, Special CID Assam Police, AIRST Guwahati, Director WPT BC, then Baska DC, Tamulpur DC, Aditya Thaklari, Rahul Dhar, and Nobo Horonia Sangshad NIC, his official address. Official address, it was given to him. So he chose not to challenge. And therefore, in my humble submission, it is not a hit case for granting any interim. If a MLA or if an MP says that I have not received this copy, when the email was sent to Nobo Horonia in his sanchad at nic.in, it is official. So, and it was sent on 13th February, right hand side, top at 1:06, 13 hours. So, in that view of the matter, Lordship, and they have not objected to it. I was expecting that they would have said that they will object to this additional affidavit, but they have accepted it as it is. So when they have accepted it, Lordship, then there is no question of granting any handle to them or giving any sympathy, showing any sympathy to the writ petitioner. Otherwise also, we are at the end of March, 28th of March. The impugn order was issued on 12th of January. So there is a delay of more than 60 days when every day is very vital. So in support of my case, I would like to place 2-3 judgments.
Yes.
Yes. Even there is a spelling mistake in the name of the caste also, that cannot also be changed. AIR 1965 Supreme Court 1557. Hayya Lal appellant versus Hari Kishan Singh and others. Paragraph 8, Lordship. Incidentally, we may point out that the plea that Dohar caste is a subcaste of Samar caste cannot be entertained in the present proceedings in view of the Constitution Scheduled Caste Order 1950. The order has been issued by the President under Article 341 of the Constitution. Article 341(1) provides that the President may, with respect to any state or union and where it is a state, after consultation with the governor thereof, by public notification, specify the caste, race, or tribe or part of or group within caste, races and tribes which shall for the purpose of this constitution to be deemed to be scheduled caste in relation to that state or union territory as the case may be. Sub-article 2 lays down that the parliament may by law include in or exclude from the list of scheduled castes specified in a notification issued under the clause any caste, race, tribe, or part of or group within any caste, race, or tribe, save as aforesaid a notification issued under the said clause, shall not be varied by any subsequent notification. It is thus clear that in order to determine whether or not a particular caste is a scheduled caste within the meaning of Article 341, one has to look at the public notification issued by the President in that behalf. In the present case, the notification refers to Samar, Jatav, or Mochi. So in dealing with the question in dispute between the parties, the inquiry which the Election Commission can hold is whether or not the applicant is a Samar, Jatav, or Mochi. The plea that though the applicant is not a Samar as such, he can claim the same status by reason of the fact that he belongs to the Dohar caste, which is a subcaste of the Samar caste, cannot be accepted. It appears to us that an inquiry of this kind would not be permissible having regard to the provisions contained in Article 341. In case of B so-and-so, reported in 1965, this court had occasion to consider a similar question. The question which arose for decision is that the case was whether respondent number 1, though voter by caste, belonged to the scheduled caste of Bhovi mentioned in the order, and while holding an inquiry in the said question was permissible, the court elaborately referred to the special and unusual circumstances which justified that. The High Court, in holding that voter caste was same as the Bhovi caste within the meaning of the order, Otherwise, it would be, it may be accepted that it is not open to make any modification of the order by producing evidence to show, for example, that though Caste A alone is mentioned in the order, Caste B is also a part of Caste A and therefore must be deemed to be included in Caste A. That is another reason why the plea made by the applicant that the Dohar caste is a subcaste of the Samar caste and thus must be deemed to be included in order cannot be accepted. So there cannot be any manipulation, Lordship. Now another judgment, 1996 3 SCC, 1996 3 SCC, page 576, paragraph 15. It is internal page, Lordship. It will be 582 down
It is
below.
for the parliament.
It is for the parliament to amend the law and the schedule and include and exclude from the schedule a tribe or tribal community or part of it or group within any tribe or tribal community for the state, district or region, and its declaration is conclusive. The court has no power to declare synonyms as equivalent to the tribe specified in the order or include in or substitute any caste, tribe, etc. It thus would be clear that for the purpose of the Constitution, scheduled tribe defined in Article 366(25) of as substituted under the Act and the second schedule thereunder are conclusive, though evidence may be admissible to a limited extent of finding out whether the community which claims the status of a scheduled caste or scheduled tribe was in fact included in the schedule concerned. The court is devoid of power to include in or exclude or substitute or declare synonym to be a scheduled caste or scheduled tribe or part thereof or group of such caste or tribe. So what does Supreme Court say? Even the court cannot do. How can that authority in 2011, the tribal association, how can they issue it? So it was void ab initio. In fact, he has got benefit for last 8 years or 12 years, which actually is not due. The law is well settled in 1965 itself and from the date of the Constitution, 26 January 1950. These articles were all along, it was there. And another judgment, Lordship, one small paragraph, 1994, 1 SCC, page 359, Palghad Pilla Khandan Samudaya Samraksha Samriddhi and another versus State of Kerala, paragraph 20.
Yeah.
Lordship will kindly come to the last page, 366.
365, 66.
366, top line. In paragraph 16, have Lordship got it?
Yes.
It is said that these authorities clearly indicate, therefore, that the entries in the presidential order have to be taken as final and the scope of inquiry and admissibility of evidence is confined within the limitations indicated. It is, however, not open to the court to make any addition or subtraction from the presidential order. There is therefore no doubt that the court in Siris Kumar Chaudhury's case accepted and followed as it is bound to do the Constitution bench judgments and not to just judgment in so and so case. That law is well settled, Lordship. Nobody can tinker with the constitutional order. So therefore, the another case, 2021, recent case, 9 STC, 2021 9 STC, page 804, Chandrabadan versus State of Maharashtra,
Paragraph
9, 10, 11. Nine, 10, 11. I'll just read Lordship 11 only. Nine is a very long paragraph. Lordship may be pleased to read that later. 10 and 11. The conclusion arrived by this court in Jagdish Balaram Bahiras are thus clear and that the impact of the legislation which come into effect on 17/10/2001 must have full and unhindered effect and operation. The 11. Once the claim of the appellant that he belonged to Halva stood negated by the caste scrutiny committee, no advantage can thereafter be extended to the appellant. Any such extension would be ruining counter to the legislation as well as the authoritative pronouncement in so-and-so case. So here, unless there is a prima facie arbitrary action or illegal action on our part, Lordship may not be pleased to interfere. At this stage, till now, even if there is absolutely no procedural lapse, although they are harping, the other day the argument was that why it is 6 members committee, why it is not 3 members committee, why it is not odd number committee. Those arguments are not forthcoming today. But the thing is that till now they have not been able to pinpoint any procedural lapse except saying that 1 report, 2 reports. So report, whether it is the first report or second report, the show cause notice was issued on the basis of both the reports together. And the first report also goes against them. Once in the show cause, we have submitted him a report. That is the report, Lordship, to which he was asked to give show cause notice reply. The first report was totally mechanical. It was solely based that he was a Saranya Kochari and his certificate is valid on the ground that in 2018, the state government issued that notification to all the district commissioners to issue certificates of STP on the basis of Sonwal Kochari. In that view of the matter, Lordship, in my humble submission, the writ petitioners have failed to project any prima facie case to attract this honorable court's interest and convince this honorable court to grant any interim order. Why I am saying the interim order may not be given. Suppose Lordship grants them the interim order and tomorrow he fights the election. We are not political rivals, Lordship. On the basis of that certificate, if he fails in the writ petition in the month of May, he will fight the election and hopefully I have all the best that he will win. Then what will happen to the people who belong to that constituency? So in another 2 months, there will be another round of election. So that Lordship would not permit.
Now let us have the queries clarified.
Deeply obliged.
I'll also come back.
Yes.
Mr. Kushit, if we go by the first report, see,
Hello.
fundamental fact is this. Your certificate declares you to be a person belonging to Bodo Katha. Fine?
That's right. That's right.
Bodo Katha. And Bodo Kathari is recognized as a scheduled tribe in Assam.
That's right.
Scheduled tribe plain, in the plain district. Plain type in Assam. Right. Now there is a complaint saying that you are not a person belonging to Bodo Katha. Okay? An enquiry was done. The enquiry says you are a person belonging to Saranya. First report. However, in the last part, it says that you belong to STP. But if you are an Saranya Kosari, you cannot be STP. Clear, Mr. Saranya?
Fine.
If
Yes,
you are
sir.
held to be a Saranya Kosari, you cannot be a STP in terms of presidential order. However, your case is that you are a
Boro Kachari.
Borokat. So, Hart's report in any way on the factual aspect will not give any right. And on the basis of the factual aspect, whatever is determination is made is having no validity. Suppose I say he is a Brahmin, but he is a scheduled tribe. It will not help you. Help a Brahmin to become a scheduled. Anyway, this is first part. So whether second inquiry is done without giving any opportunity on the basis of giving a report to you, is it having any relevance in the context of finding of the committee? This is procedural, question of procedural. Other parties, by virtue of Madhuri Patel, the state in its wisdom issued an executive instruction for laying down the procedure. That procedure, certain rights are given to you, even for a cross-examination, leading evidence, everything.
Please.
You have not opted for it. This is for prima facie for the determination of an interim order. Okay, because factual aspect determination, whether Bodo Kosari or not, that is a larger issue. This is prima facie, we will have to have a prima facie certificate. Third aspect is that, okay, fine, but where is the reason of rejecting me? For other ground is that there is no finding on the fact that the certificate issued by tribal Sangha is fraudulent. That will be your argument. We will have to balance between these.
Grateful, my lords. My lords, very, very, very grateful. My lords, may I,
Yes, proceed.
my lords, may I answer them in sequence? But before I answer them, your lordship will permit a little memory I have of a Peter Sellers film. Because Peter Sellers was at a particular point, he was looking at someone who had a dog by them, and he said, "Does your dog bite?" And that man said, "No, my dog doesn't bite." So Peter Sellers picked up the dog, and the dog mauled him all over the face. And he said, "But I thought you said your dog doesn't bite." And the man answered saying, "That's not my dog. This is someone else's dog." Well, what's happening here is that the inquiry seems to be, are you really a tribal because you are Saranya, whatever? Are you a tribal? Where is the inquiry had to be, are you a Boro Kachari? That was what the certificate was. The certificate
You are
was
correct. The
Boro
certificate
Kachari.
was you are Boro Kachari.
You are Boro Kachari.
Now
Saranya-
they find that you are not Boro Kachari, you are Saranya or
So-
post.
So, my lords, I could be Boro Kachari and Saranya both. My lords, that's my submission, that I could be Boro Kachari and Saranya both, because Boro Kacharis or Boros, tribals,
That's
were
correct.
changed to become Saranyas. So this Saranya is a distraction. This Saranya is a distraction and something that the government tried to do or wants
No,
to do.
that's correct. There is no quarrel on that point.
I'm
Even
great-
being a Boro, it can be a Saranya. Your title will not make any difference.
Grateful, my lords, grateful.
Your title will not make, suppose you are a Boro, because that presidential order nowhere says that it should be the title should be basis. The determination is whether you are Bodo or Boro Kachari. The first report says while determining your social status or caste status, it says you are Saranya Kosari. Moment they declare you are Saranya Kosari, because it was not relating to your title, it was relating to a reference to determination of your social status. That is where it is says you are Saranya Kosari. So if you are Saranya Kosari by virtue of your social status or caste, you are not Boro Kosari, you cannot be both.
My lords, you can't.
In terms of that, by
can't be-
title, no problem on that.
Certainly. So, my lords, can't be both, but the fact that Saranya, as I said, is added on to whatever you are. So,
yes,
but Saranya could be added to Boro, Saranya could be added to
Either
Boro Kachari, Saranya could be added to Kachari alone, because all three are within the tribal list. Kacharis, Boros, and Boro Kacharis are all three in the tribal list. Now, I am claiming to be a Boro Kachari. I'm claiming to be a Boro Kachari. My certificate was given as a Boro Kachari. But unfortunately, because of this common use of Saranya, etc., Saranya has overtaken me, and everyone thinks that they have to see whether I'm Saranya. And if I'm Saranya, then I'm not a tribal. So I am not, my claim is not I am a Saranya. My claim is that I'm a Boro Kachari, and Boro Kachari is a title. So that's one point, my lords. Is a tribal. Now that's one point. My second point, my lords, is
why I am asking this, that we understand. Why I am asking this question is because one of the argument is that first report is in your favor.
My lords,
in
of course.
fact, first report is not in your favor, against you.
My lords,
is that it, Mr. Saranya?
My lords, I'm grateful because the report uses the term Saranya because that had become a common usage by then. Your lordship asked a very important question to my learned friend. This certificate was given in 2011. The notification my learned friend was talking about was of 2018, and then it was revoked after 2018. But it must have been in the atmosphere. There was this talk of Saranya, there was this talk of Saranya, Kachari, etc., and therefore he was influenced into using the word Saranya. Be that as it may, my lords, there was a report saying that I am a tribal. Now, if there is some deficiency found in that report, there has to be a procedure by which that deficiency will have to be corrected. Would that report be set aside, or will that report be treated as a preliminary report? My learned friend has used the word preliminary. He has used the word first report, continuing report, second report. That I believe is not permissible, my lords, at least at this stage, for your lordship's consideration. At this stage, that is not available. My lords, I have two judgments that I will cite to you. My lords, one is a Supreme Court judgment. That's the Maharashtra judgment. Although it's the generic Adivasi Thakur Jamaat, my lords. This is a generic.
Adivasi Thakur Jamaat, recent judge, 2023 SCC
Please, my lords,
326.
your lordship rights is para 33 is all I'm reading.
Paragraph 38.
36, my lord, those are the conclusions. If I may just read the conclusions to your lordship. Only when the scrutiny committee, after holding an inquiry, is not satisfied with the material produced by the applicant, the case can be referred to a vigilance cell. Your lordship may recall that when I started my arguments,
Understand.
that how do you refer it to the vigilance cell? While referring the case to vigilance cell, the scrutiny committee must record brief reasons for coming to the conclusion that it is not satisfied with the material produced by the applicant. Only after the case.
That's why in the morning I am saying use the word affinity test.
Your lordship.
I intentionally use that word affinity test in the morning.
Your lordship did. So, Lord, if I may just complete this, only
Yes.
when the case is referred to the vigilance cell for making inquiry, an occasion for conduct of an affinity test will arise. My lords, your lordships are right. Your lordships had raised that. Then B, for the reasons which we have recorded, affinity tests cannot be conclusive either way. When an affinity test is conducted by the vigilance cell, the result of the test, along with all other material on record having probative value, will have to be taken into consideration by the scrutiny committee for deciding the caste validity claim, and then it goes on to say.
So therefore, in the morning hour, reading the report of the vigilance committee and the inquiry, findings of the inquiry, it is a kind of an affinity test they have conducted.
That's right.
Going through the caste of marriage, etc. In fact, the affinity test to an extent is prescribed in the their procedure. So therefore, that's why I put you that question in the morning.
Please, my lords.
On the basis of this judge. Yes.
Your lordships will note that this is 3 judges' judgment.
I have seen that.
And
Recent judgment.
So, and recent judgment, your lordships.
Now, just clarify one point, whether this conclusion is on the best any prescription in the Maharashtra rule. Because Maharashtra, the 2000 rule came in on the basis of after Madhuri Patil, and it was held that after Madhuri Patil, this rule will be holding
will prevail because the Maharashtra rules come along. It is the judgment is obviously in the context of the Maharashtra rules.
Maharashtra rule, whether this prescription is in the Maharashtra rule or not, or it is under it's a general conclusion.
Well, this is a generic file, as I understand. I will check it again, and well, there's one last judgment that I want to show to your lordship. That's only one paragraph. Well, that's 2021 9 SCC. That's Chitra.
Chitra.
So Chitra, I will just show one paragraph in Chitra. That's para 10, my lords.
8.
Para 10 and page 817.
Para 10.
Para 10 at page 817. If I may read that to your lordship. In the instant case, an inquiry was conducted by the district level vigilance committee, which has upheld the community certificate in favor of the appellant. The decision of the district level vigilance committee in the year 1999 has not been challenged in any forum. The recognition of the community certificate issued in favor of the appellant by the district vigilance committee having become final, the state level scrutiny committee did not have jurisdiction to reopen the matter and remand for fresh consideration by the district level vigilance committee. The guidelines issued by GO number 108 of 2007 do not permit the state level scrutiny committee to reopen cases which have become final. The purpose of verification of caste certificates by scrutiny committee is to avoid false and bogus claims. Repeated inquiries for verification of caste certificates would be detrimental to the members of the scheduled castes and scheduled tribes. Reopening of inquiry into caste certificates can be only in case they are vitiated by fraud or when they were issued without proper inquiry. So, my lords, these issues your lordships would certainly be able to consider in the final hearing. My lords, at this stage, I would urge your lordships to consider that someone who has already served, my learned friend said that he has had a bonus of 8 years or 4 years, etc. But someone who on a valid certificate has served this country in parliament has a right to appear in the elections that are now around the corner. But of course, subject of course to your lordship's final decision. And if a final decision means that there has to be a re-election, then it has to be a re-election. Well, that happens in so many cases. It happens in election petitions. It happens in many other matters in which elections are set aside. Because in a democracy, you balance the right to the voter with the right of the state to ensure that the best people serve the voter. Well, that's my...
Now address us as regards the third contention of not challenging the final caste certificate even after received the intimation on long back on 13th.
I'm grateful, my lords.
Just-
I'm glad. My lords,
Since he has raised it, we'll have to address it.
I know, my lords, I'm grateful. My lords, as far as my instructions go, that we have received on to 20th of March, we have received the email today.
2:16.
There is no mention here that this email was sent to me earlier. This is sent at
2:16 p.m.
at 2:16 p.m. today. My lords, fortunately, as your lordships had noted earlier, fortunately, I have said all consequential orders also to follow. Now, if the route goes, my lord, the consequential order will automatically have to go. That's my submission, my lords. In view of this, I will be deeply grateful, your lordships, to consider my interim relief. Deeply grateful, my lords.
Mr. Saranya, what is the urgency? We'll hear it. Don't worry about it. You have given so much of patience, keeping everybody awaiting. We'll keep you hearing who you are.
Why not the notification has been issued only that it is published in the Gazette notification file. So communication has to be filed.
Yes, Mr. Duff.
Taking the last point part, my lord, in our
I think
caveat
the Advocate General has
has
covered everything.
everything.
Anything
But
if you want to supplement, that's all.
I would like to supplement one thing only, that the order dated 20th January 2024, cancelling the caste certificate, was annexed with our caveat that was filed on 7th February 2024. Therefore, they have a copy. And my lord, this not being challenged, there is no final order, that final relief cannot be given to him at this stage. And if no final relief can be given, no interim relief either can be given. In that respect, my lord, I can place before lordship one judgment of Supreme Court 83. 83 483, Cotton Corporation of India, that
Order 39.
yes,
Order 39.
কই গেল কোথায় গেল
When there is no relief,
এই এদিকে আসো
relief sought for permanent injunction, no temporary injunction can be.
yes,
Isn't that it?
yes, that when no relief can be given finally.
Here is that cases when no prayer for temporary injunction is there, permanent injunction is there.
Yes,
No temporary injunction can be
be-
granted under Order 39, Rule 1 and 2. Is it not? Yes.
yes. Here also, my lord, they are not claiming any permanent relief so far as the cancellation of the caste certificate is concerned.
So therefore,
Therefore,
where is the question of saying the subsequent?
And my lord, to supplement whatever has been submitted by the Lord Advocate General, my lord, Madhuri Patil says about guideline. It is not to be strictly followed. It is only a guideline.
Don't
Paragraph
say that, Mr. Das. Don't say that. Then it will be very difficult. Object of Madhuri Patil and laying down the Gandhi's thumb, more or less, this has become a law. This is a law.
Yes, that is the law. That is the law. In the
So what
absence
should
of-
be the prescription? In that view of that, they have done it. Mr. Advocate General's argument is that yes, we have formulated this guideline and we have strictly followed. What remains?
Yes, yes. It was strictly followed. It's about my lord, the first report and second report, all these things. Your lordship, please to see if page 64.
Page 64 of Madhuri Patil.
No, my lord, read petition.
Okay.
64.
The rule says this. Finally.
Whatever is said about the initial report or the preliminary report. No. It is 63, madam.
Which paragraph?
Second paragraph at page 63.
Yes.
Your lordship has noted it that the inquiry officer says,
Saroniya Kosari, which is under purview of STP.
STP, that is because of the government's letter. One government letter which has been subsequently withdrawn.
On 18th.
18th.
Because on 18th, Saroniya Kosari were directed to be
STP.
STP. On that basis, this report has been given, whereas his certificate was of 2011.
Anyway.
So therefore, on the basis of 2018, on that day, that might be actual fact, but actually it is not. So
Yes.
therefore, this report is after 2018 having no relevance. This is your argument, isn't it?
And whether page 180.
Page 80.
80. The second report.
Yes.
Now, what the SLT state level scrutiny committee is to decide. State level scrutiny committee is to decide about the caste status of the social status of the person concerned. Now, I have given a complaint to the authority concerned to look into the matter. Therefore, they are determining the caste status. At page 80, a middle portion, taking into consideration the practice of the Boro. Navakumar Saroniya's parents was not conducted according to the traditional rites and rituals of the Boros and Rabars. Further give credential to the contention that the Navakumar Saroniya and his ancestors are not tribal and that they did not belong to the Boro Kachari community. But
now I'll put you a question. If you argue on this, these are the final hearing matter. When there is suspicion, where is the conclusion on the basis of this suspicion? On what material?
I'm saying, whether NRC data and the statement of the Gavoda, he gives a finding at page 79 that he belongs to Sorukos. No, Sorukos tribe. Sorukos is not a recognized scheduled tribe in Assam. It may be in Meghalaya, possibly it is, or
Let us not go to all these disputes.
No,
for the time being.
It is not a scheduled tribe in Assam.
Okay.
At page 79.
See, this report, since you have started, if you go to paragraph 10, again that the custom practice, those has been entered into. This is called affinity test.
Yes.
Is that it?
Yes.
What their Navakumar's parents was not conducted according traditional rites, marriage ceremony, these are the called affinity test.
Yes.
Now, when affinity test is essential, not this is another aspect. when the affinity question of affinity test will arise, that will depend upon certain different facts. Whether there is a tradition, they are following the food, culture.
But page 77, my lord, your lordship.
Yes.
Paragraph 2, findings. Then paragraph 5.
Is an affidavit required by an officer to determine that Soronia Kosari
that
is
was
not scheduled
in the
caste?
context.
Is it an evidence? Is it an evidence? Presidential order is
Yes,
sufficient.
presidential order is
Then why this whose affidavit, who has filed, is it a relevant thing?
relevancy only to the extent that he is echoing what is there in the presidential order.
Echoing is not necessary. Who is this Vinita Pegu
Yes,
filed
yes,
affidavit in some writ petition saying that so and so? Where is her affidavit is required?
But the fact remains.
If these are the evidence to come into conclusion, then we'll say prima facie it is perverse.
I'm not saying so.
So if prima facie perverse, why should we believe this record? Give us the
Well, so far as the stay part is concerned,
we are on stay only. We are on stay only. We are going to the merit.
No, I am not going to. I am not going to the merit. But so
See,
far as
clerk, come to clause 4 that you are reading. WPC so the Honorable Guwahati High Court has observed that Sonoria is not enlisted tribe in the list of scheduled tribes.
No, I am not teaching.
Need not observe. This is a document, public domain. It is not. Sonoria Kosari is not an included in the list. Only Boro and Boro Kosari. So far relating to Boro, there are two only, Boro and Boro Kosari.
Yes.
He claims to be Boro Kosari. His certificate is Boro Kosari.
Yes.
He says, my name is Soronia, but I am Boro Kosari. Your finding says this now. These will be
but the state level scrutiny committee has said,
for that you do not need an evidence of some gogoi saying that it is not included in the list. For that what you need is the presidential order.
Yes. The fact remains whether the presidential order does not include Soronia Kachari or the
admitted.
And the fact remains, whether as my learned friend, Advocate General has submitted, that Soronia Kachari are agitating their demand for their inclusion in the STP and
that is not the issue before us.
But that is
our issue before us is whether the determination that what is the determination and whether his caste certificate was good or bad.
Bad.
For that, a fact finding is required. That has been directed by the vigilance. Now that report is given. On the basis of report, a conclusion is made. Whether prima facie that could have been done or not done, we'll have to decide. And if it is prima facie fine, okay, we'll not pass and stay order. We'll see the balance of convenience, irreparable loss. Then we'll think about it. That's why I'm asking. I am delivering this order either Friday or next on 27th.
One day.
Because the election
that's
7th of May. So we have lot of time.
That if 7th of
Maybe
May.
for the final disposal also Lordship may consider matter in the first week of April.
Okay. So we are
Notification
taking
for that will come about in
call on 29th we are delivering. I do not think it will be too late.
29th is the holiday.
No, 27th.
I'll just give one.
27th. Possible? Just
Yes.
listen to the order.
Yes.
Heard,
Lordship, I have just want to.
No, just we'll hear you. Just heard Mr. Salman Khurshid, learned senior counsel, assisted by Mr. Sarania, learned counsel for the petitioner. Also heard Mr. D. Shaikia, learned advocate general, assisted by Mr. K. Gogoi, learned counsel for the state of Assam, and Mr. B. C. Das, learned senior counsel, assisted by Mr. Sohan for the respondent number
8.
Respondent number 8. issue notice returnable on given date. For notice, because we are passing an order, issue notice returnable. If you want somebody want to exchange pleading, we are fixing this matter on 27, hard on interim, returnable on, just think a date, in the meantime, hard, hard
During
the-
this month,
heard the parties on the interim prayer.
28.
Hearing concluded. Let this matter be listed on 27 for delivery of order on the interim.
Okay.
That's all.
Only,
Okay.
on,
Yes. Now we.
regarding the judgment which my learned senior friend placed shortly with 2023 AIRSC 1657.
That
Maharashtra. So there is in paragraph 5, there is a specific relevant to rule 12 of the ST
That
rule.
is what I have asked.
Yes.
That is what I have.
That is, there is a specific provision.
Because
Under
it was
the
there.
procedure was laid down. So
This,
that has nothing to do with us.
where is that procedure?
Procedure, Lordship will see the contention of the parties, paragraph 5. Next page, on top, 4 lines from top. He submits that if such document in support of the Caste claim are presented before the scrutiny committee and if the same are found to be relevant and genuine, there is no occasion for the scrutiny committee to order an inquiry through vigilance cell. Similarly, if blood relatives of the person applying for the verification before the Caste scrutiny committee has been granted Caste validity certificate, no further inquiry by the scrutiny committee is called for. In both cases, it is the duty of the Caste scrutiny committee to validate the caste certificate. He invited our attention to Rule 12 of the ST rules, which lays down the procedure to be followed by the scrutiny committee.
You are reading at paragraph 5.
Paragraph 5.
Next page that produced by the applicant, it can order.
He invited our attention to the, about 6 lines from top.
In the next page.
In paragraph, if Lordship is having
above paragraph 6.
Above paragraph 6, yes. He invited our attention to Rule 12 of the ST rules, which lays down the procedure to be followed by the scrutiny committee. He pointed out that sub-rule 2 provides that only if scrutiny committee is not satisfied with the documentary evidence produced by the applicant, it can order inquiry through vigilance cell. It is just the reverse there.
That is why I asked that whether that context was in relation.
Not at all applicable here. Number 1. And number 2, Lordship, that PIL 30. PIL 30/2019, Kalbari Educated Unemployed Organization. Their challenge is that paragraph 3, this PIL is instituted by Kalbari Educated Unemployed Youth Society, another assailing the notification of 2009 by the Secretary of the Government of Assam in WPT and BC Department, by which it was provided that the Governor of Assam is pleased to authorize Vice President, President of the Assam Tribal Sangha and district units of Assam Tribal Sangha to identify the status of scheduled caste tribe communities and issue certificates to the scheduled tribe P and scheduled tribe H in Assam within the jurisdiction of their respective districts and subdivision temporarily till finalization of the amended rule 3.1 of the Assam so-and-so rules 1983. The next paragraph, the petitioner also assailed the communication dated 5/6/2018 from the Commissioner and Secretary to the Government of Assam in the WPT and BC Department made to all DCs and subdivisional officers in the state as regard issuing scheduled caste plain certificates to Soronia Kosari community as Kosari tribe in Assam. So this was put to challenge.
It was withdrawn.
Now, Lordship will kindly come to paragraph 9.
9.
As regard to other notification dated 5/6/2018, by which the Commissioner and Secretary of the Government of Assam in the WPT and BC Department has provided that all the persons belonging to Soronia Kosari community will be issued STP certificate under subtribe Kosari. The Secretary to the Government of Assam in the Tribal Affairs Department has made a statement before the court that the said communication meantime had been withdrawn and it will not have its effect under the law any further. As the communication providing that Soronia Kosari community will be treated, will be issued, the STP certificate had been withdrawn, we are not required to adjudicate the matter any further. So this
because
that's a mistake.
That was challenged because you don't have any authority to
Exactly, Lordship. And government has realized
that
this
is to be under a presidential order notified then only.
That
How
was
can
why
state
already it was adjudicated by this honorable court on this point.
My certificate was not issued on the basis of
no,
certificate.
understand. See, that is in the context of the first inquiry report. First inquiry officer says that he is a Saranya Kosari. Your whole argument that the inquiry report you are relying on, which you are saying to be the first inquiry, itself ascertains you are Saranya Kosari. Isn't it? If you are Saranya Kosari, till now you are not notified as a tribal. That is their argument. That is there, isn't it?
That is my case.
Yes. So the argument that first inquiry, second inquiry, even if is admitted, that goes against you according to. Isn't it?
Yes, yes. It's a admitted, undisputed fact. Undisputed fact as on date.
My lord, that is
So there is
different,
no
my
question of prima
No, no,
facie
understand.
or
Your case is, we understand, your case is that certificate was issued to me as Boro Kosari. Whosoever, whatever is said is irrelevant for me until and unless it is found that this certificate is bad or fraudulent.
fraudulently obtained or
Fraudulent.
whatever it is.
But there is a procedure prescribed where a person can make a complaint that this is not a genuine. Then they have a power to determine under Madhuri Batil, they have issued a notification. Now we'll have to balance for
we
the
are not saying that certificate is fraudulent. We have said wrongly claimed. Wrongly issued.
Wrongly claimed. Okay. लिख लेना. Okay.
Highly obliged.
Okay. For delivery of order in the interim on the interim prayer on let the
That is Lordship's homework during the holy.
I love.
Deeply obliged.
thank you, Mr. Kusit. Thank you, Advocate General, everybody.
Thank you.
Thank you.
We should seek
Thank you very much.
apology from the others.
I have to.
We should
I
seek
have to walk
apology
to the
from the
podium.
others. I
All the
think
others.
this will be the first day that I have not finished the list.
Oh,
Well, it is our, we were lucky to had
No,
a
I
full
have.
hearing.
You are lucky. I am unlucky because first time I have not finished my list. Will not be able to finish my list.
Well, we can only wish that this doesn't happen again. Thank you, Malad. Thanks very much.
Highly obliged.
From scheduled caste to tax.
Not that much CIS. In petition, I'm challenging two orders at the lordship and case.
This is a motion, no? Yes, where is Kyle?
Not carry that there, bro.
Huh?
Cal is not there. Central government and play.
Kyle was there. He said that because of you were not there.
Cal is in exercise. This is not exercise matter.
Who was? Somebody was there when matter was called.
It's the part of Viva's part of.
What to do? Day after tomorrow? Day after. Okay. On the prayer of the who you are CGSC.
Oh.
Mr. Gogo, release this matter day after. 22nd.
Sorry to disturb.
Yes.
Item number 40, there is an interim stay. So
In whatever is interim, you just give the cases. We'll extend. We have some important matters.
58, 59 eviction matter.
Eviction matters and that eviction are some there are some motion, and we have asked some instruction at 2.
Yes, 58, 59.
Yes, yes.
That matter, my lord, 58 and 59, that concerned commissioner has stated that they will not acted upon in the impugned order, my lord, as it was not placed before earlier order was not earlier known to them, my lord.
We'll record it.
My lord.
Earlier also it was recorded, but this time we'll not spare. Give the item number.
58.
Verbal instruction.
My lord, can I date be given?
See, whoever wants a date, give. Just wait for a minute. For others, those interim orders, please make a mention. We'll verify and accordingly pass an interim order. And those who wants us real urgency, I'll just requesting real urgency is there. Then also we'll fix a date. If there is real urgency.
Then I'll take your date.
If there is real urgency, then give a date as per you propose. We'll fix it. Sorry, it generally will not happen, but no way out. Oh, okay. Call the motion. Left over.
The petitioner's application is pending with the Latmandal, and there was a hearing on 28/12/23 regarding the partition. However, as per the record, petitioner was not present on the date of the hearing.
Have you
And-
issued notice to him?
My lord, that,
Because see, because he is interested. Otherwise, he would not have preferred an appeal. He would not have preferred a second appeal.
my lord, also the Latmandal says that he could not be contacted for verification of his possession. That
We are taking up this matter next week again. You have a proper instruction in terms of the earlier order.
my lord.
Okay.
I
And
submitted-
if necessary, file a short affidavit. Mr.
Yes.
Das, okay. Ms. S. Sharma, learned counsel for the respondent, submits that she has received some instruction in terms of this court's order dated 18/3/2024, but such instruction is incomplete. Incomplete. Accordingly, list this matter 28 or 29 is the holiday.
29,
28,
Lord, can it be on 1st of April?
first of April.
Apply.
First.
Apply.
Na motion kolo.
Item 58.
My lord, may please to issue notice that they will file a petition. In the meantime, Lordship will stay the engrossment case 4/23/24.
Third, Mr. Talukdar, learned counsel for the petitioner, also heard Ms. Borman for
Respondent number, my lord, P4.
3 petitioners or 1 petitioner.
Here, my lord, 3 petitioners, my lord.
And what is about the second case?
Second, my lord, same.
3.
3 petitioners.
3 petitioners. Allotted, just correct me, allotted 3 rooms of a market at Hanga Bazaar Road.
Right.
Hanga Bazaar Road under Bodarpur Anchalik Pasar in the district of Karimganj. Karimganj, way back in the on 24/1/2006, 20/09/2018, and 29/7/2022.
Right.
And what will be the others? Give a list.
Only 24/1/2000.
All
All
second case.
same, all same date. All same.
Sure. You just record this date. Let us not confuse him
Correct.
with the dictation.
Correct.
Okay. You just note.
Correct.
Full stop. According to the petitioner, after allotment, they had made investment and had developed the rooms. Thereafter, a notice was issued on 20/02/2023 by the President Badarpur Anchalik Panchayat, directing the petitioners to vacate the allotted rooms on or before 15/3/2023. Being aggrieved, the petitioners prefer. This date will be same for others also. Okay.
Same.
The petitioner preferred a writ petition being WPC 1236/2023.
And another is 139.
No, you just write it down. You will have to give it later.
What?
2023. 2023. This court, while this court disposed of the said writ petition with a
9/3/23, my lord.
with a direction, dispose of the aforesaid writ petition by its order dated 9/3/2023. Dispose of the said writ petition at the motion state itself by holding that the petitioner
Lordship may quote our court the last paragraph. Hearing.
with the following direction,
Right.
page 39. The present writ petition is filed assailing that even after such order being made known to the respondent has neither complied with the aforesaid order. The respondent without complying the aforesaid order and without entering into a memorandum of understanding, has now registered an enforcement case being
Case number 4 of 23/24.
case number 23,
No, case number engrossment case number 4 of 23/24.
enforcement case number 4 of 23-24.
Before the, my lord, the court of collector at Karimganj.
Before the
Court of
before the
collector.
court of collector at Karimganj, and a notice under section 18(2) of the settlement rules has been issued for their eviction. Mr. M.S. Bormon, on instruction, submits that from the deputy collector,
Additional Deputy Commissioner.
from the additional deputy collector.
In earlier writ petition, my lord, Deputy Commissioner was not
Not
made
yet.
a party, my
Okay.
lord. so it
Additional
was not
deputy
brought
collector
yet.
submits that the
Writ petition.
additional deputy collector was not aware of such order, and accordingly the notice was issued. However,
They
they
will not
are
act
in
upon
view
that.
of their knowledge, they are not proceeding
act
with the
upon
enforcement case. In view of the submission, let a notice be issued returnable
For
after 4 weeks. Steps, you accept notice, who accept notice, what, please give a note.
3 and 4 in
Three
both
and
the
four,
writ petition, I am
considering the matter in entirety, and the order dated 9/3/2023 passed in WPC number Swenso and Swenso. The enforcement case
4 of
4 of 2023-2024 is provided shall remain suspended. 58-59, 59, give the date. Don't say that there is a mistake and file an IA. Will not allow.
Apologize.
Yes.